where the respondent number 3 had filed a KVA, which has not been put up by the registry. And subsequent to that, there was an interim order of stay by this honorable court, my lord. We have filed a necessary application for vacating the stay. The respondent number 3, my lord, kindly have it tomorrow, my lord. The respondent number 3 has already taken charge on 31/7/24.
We'll hear it.
Subsequent to that,
Yes.
Any mentioning? List 1, page 1, seal number 1 to 5.
Serial number 5, Your Lordship, I appeal for appellant. I have received the statement of objection. I need to file IA for additional document. Kindly, week's time may be granted, Your Lordship.
My lords, I'm fine. I'm only asking for a clarification of the stay which was granted on the last date of hearing. There are separate commercial disobedience proceedings which are ongoing. The stay here was granted only on the commercial suit 1310. I'm only seeking a clarification of the order to the extent that,
To clarify, it can only be as to the,
my lords, the order says that proceedings before commercial court may be stayed. Both the proceedings are ongoing before commercial court. And on the last date of hearing, the opposite.
obedience proceedings are not the subject matter of the appeal.
Subsequent proceedings, my lord,
They're not the subject matter of this appeal.
it is a
No,
Whatever is the subject matter of the appeal, those are the proceedings that are stayed.
My lords,
That's not obvious.
my lords, they're seeking a adjournment on this ground. Hence, I'm seeking a clarification.
my lord, miscellaneous petition has been filed for the disobedience of the interim order granted in the commercial suit. My lord, in fact, the order was passed in the suit which is not maintainable, which do not have any jurisdiction, my lord. Therefore, my lord,
Hear this next week.
My lord, my objections are
the
already
mean,
filed.
my lord, interim order of stay may be extended, my lord.
Yes, till the next date of hearing.
Please, my lord. My lords, any date may be fixed or next?
19th,
Much obliged.
Much of-
page 2, seal number 6 to 9. Page 3, 10 to 12. Page 4, 13 to 20. Page 5, 21 to 27.
Have you informed the other side? Yes. When do you want it?
27th. Page 6, seal number 28. List 1, admission, seal number 1, SG Bhagwan.
Yes. Sorry? Hmm. You are the second defendant? You are the second defendant?
Second defendant is actually the default. I've taken out the let apart. No suit to impose a right arising from a contract shall be instituted. No suit shall be instituted in any court. Why I answer first against any third party unless the company is registered. The persons suing have been shown in as partners to the court. In this case, judgment is closed. Bring it more and more represented by its partner Produced.
Instituted in court by a on behalf of any person suing as a partner in a firm against the firm. Is against the firm, it was registered.
When it's 25, but they are not taken such.
Not only that,
May I, my lord?
not only that, it is not for in brief or on behalf of any person suing as a partner in a firm against the firm. It means the partner against the firm. Yes,
May I? My lord, it's actually a registered partnership firm, so. In fact, M- my lord, this contention was not at all raised before the trial court, either in the written statement.
what does 69 say?
My lord,
What does section 69 provide?
my lord, no suit to enforce, I'm reading subclause 2, my lord. May I?
Yes,
No suit to enforce a right arising from a contract shall be instituted in any court by or on behalf of a firm against any third party, unless the firm is registered and the persons suing are or have been shown in the register of firms as partners in the firm.
you've stated in the plaint that it is a registered firm.
My lord, these documents were produced before the trial court. May I please bring this to before the trial court also, please, my lord, if I may. The order sheet of the trial court may kindly be taken, my lord. Hence, I was just submitting that in the written statement, this contention was not taken up, nor was this contention taken up during cross-examination. If my lord takes the order sheet of 19 to 24, my lord, that is the day when both parties jointly submitted arguments, the first day. And the case was posted for judgment the very next day.
Just a moment, 19.
19 to 24, my lord, order sheet of the trial court. On 19-2 is when both parties for the first time submitted their arguments. It was at that point that the counsel for the defendant number 1 raised this point. That is why on the very next day, my lord, which is on 20th, I have furnished the originals of both of these documents to the court below. 20th, my lord, is case called out in open court, advocate for plaintiff present, and filed a memo along with 2 original documents, my lord. These are the 2 originals documents that I've furnished the copies of before this court. Call later. Case called out in second half, no representation for defend number 1B. Advocate for plaintiff present, my lord. Then the judgment is passed during the course of the day. There was just one day, my lord. 19th the arguments, we submitted our arguments. And only at the time of reply for the first time, the counsel for defendant raised this point. Immediately the very next day, I produced both of these documents before the court to show that I'm a registered partnership firm, my lord. The documents are Please, my lord. Even in the written statement, no such contention was taken up. That is why I did not have the opportunity to file them during evidence, my lord. Else I would have done that during evidence itself, my lord. Nor in my cross-examination, anything of this sort is forthcoming. With regard to the merits of the case, if I may please submit, my lord may kindly just take up the cross-examination of DW1. It is just 3 pages.
What do you say? Now, it appears that it is a registered firm. You had not taken such a contention in the written statement as well. 27.
Statement. And otherwise 15.
Yes, 27. Yes.
In regard to partners between the firm, is concerned, all the partners need not be sued. One of the partners and depose on behalf of the firm. Nothing to show. that this particular document which is not to be used now is produced then or referred to within the next stage. Therefore, your lordship will call for the records, post the matter any day.
The records are here.
The originals is a part of the record, my lord, authorization letter as well as the registration.
And it should be.
This is contention. They have filed returns. But they
There
have
are-
not taken such plea. Even no issues framed. Now they have produced documents to show that they are petition. They have proceeded.
Yes.
In the annexure to the judgment note, there is no reference to this document.
Sorry?
There is no reference to this document, which is certainly have to be found.
It does not have.
Page 29.
Yes.
He is having produced. There is definitely a reference. Whether traffic government or not.
It is mentioned in the order sheet, my lord, both of these documents.
Yes.
They have never taken up this contention before final arguments, brief final arguments, only in the final argument stage did they raise this contention. That is why immediately I have produced it. Yes, very next day I have produced the document before the court.
The section is clear. No suit will enforce.
I'm a registered partnership firm, my lord.
The object of section 69(2) will be frustrated unless this particular document accompanies the claim.
Apart from that, is there any contention you have to raise on the merits of the matter?
Paid the amount to the third party, which he owed. I paid it immediately. Therefore, that has to be considered.
My lord, to rebut that, may I please take my lord through their cross-examination? It's only 3 pages. It encapsulates everything, my lord. The cross-examination of DW1, please.
Yes.
Please, my lord. May I continue? My lord, please, my lord, because even the execution proceedings,
So, well, let's see.
Near the day.
my lord, proceedings are also stayed of execution.
14th,
Please, my lord. 14th, please.
Say,
My lord.
List on 14th. Interim order granted will remain.
My lord, there is no interim order. On previous date, I had given an undertaking.
Yes,
I will not precipitate.
yes, list on 14th.
May I just seek, my lord, one analysis? My lord, matter was mentioned for serial number 22, my lord. But my lord, execution has been filed. My lord, he's appearing for caveator, my lord. My lord, execution has been filed and 19th August is the date, my lord. So now he informed me that he has taken time and matter is now.
Any prior to
Not
the,
precipitate.
any prior to the 19th may be date may be given, but any,
19th, we don't have a date, council.
that is what, any
Yeah.
prior to the 19th. madam.
There is no date prior to 19th.
My lord, I am
Sorry.
ready for my lord argument today, but my lord, he has some. my lord,
Personal incomes, that is what I mentioned.
Please don't precipitate it on the 19th.
On that,
It on 19th itself.
on that I inform the
Yes.
public to take it.
It is submitted that the matter will
My
not be
lord.
precipitated on the 19th. Yes.
Obliged.
Mr. Anand.
Obliged.
Bill number
14.
2, Manu Prabhakar Kulkarni.
Please appear for the respondent. Lord, this is the claimant's appeal under section 37. Lord, in terms of very brief facts, my lord. The claimant, may I request the lordships, my lords, to kindly see 2 paragraphs from the award for the brief facts. The award, my lord, your lordship will please find. Paragraph 47 at page 154, if your lordship sees. Just two paragraphs on the facts. This is a part, my lords, of the award. It is an admitted fact that the claimant, who's also the appellant before your lordships, the claimant was building an integrated steel plant for the manufacture of pig iron at the total cost of rupees 282.9 crore. The fuel to ignite the blast furnace in the integrated steel plant is power. Purchasing power from the grid would increase the manufacturing cost of the iron. Therefore, claimant decided to build a blast furnace gas-based power plant. For the functioning of the blast furnace gas-based power plant, air-cooled condition system was required to be erected and commissioned. For supply, installation and commission of ACC system, the services of the respondent were engaged and the total cost of erection and commissioning of the ACC system, including spare parts for 2 years, was rupees 3.05 crores. Lord, I was building, my lords, a steel plant. To use captive power, I engaged the services of the respondent. My lord, the scope of work of the respondent was to install and commission an air-cooled condenser system. Admittedly, they did not complete the job. Now, your lordship may kindly see, my lord, para 27. The reasons that start with the award. The first paragraph captures, my lord, some of the facts that may not be in dispute. Para 27 at page 141. Undisputed facts are that there was a techno-commercial discussion held at claimant's office at Hospet in Ballari district, Karnataka between claimant and respondent on so and so with regard to the ACC proposal. And in that discussion, it was agreed between the parties that the approval from the claimant company had to be taken for the revised P&I diagram, that in furtherance of discussions held at so and so, the respondent sent an offer by email dated 9/8. And in that email, respondent had stated that the prices quoted by it in the said email were valid for 2 months. Then, my lords, your lordship may just kindly see the last line. As per the tender specifications for ACC system given by, this is SAIL, Steel Authority of India Limited, it is wrongly written as SALE, Ranchi, as mentioned in the LOI, that the date of LOI is 9/8/2010, that as per the terms of the project was to be completed by 9/5/2011, that Hirehal of the claimant company visited the office of the respondent at Kolkata on 7/12/2011, that on 17/12/2011 fresh dispatch schedule was agreed and the project was agreed to be completed before 31/5/2011, and that the respondent completed mobilization of erection team on 17/6, that on 27/6 so and so MD of claimant company visited the respondent company, and in the presence of Mr. so and so director of respondent company, fresh schedule for erection was agreed, that as per the fresh dispatch schedule, the project was agreed to be completed by 30th of August 2011. These, my lords, are the facts. Now, my lords, my respectful submission as to what were the issues. It is my case, my lords, that, and it is not disputed, they did not complete the project. Therefore, I had to complete the project taking assistance of third parties. Therefore, I made a claim. The respondents made a claim on the basis that they had done more work than they were actually paid for. My response to that, my lords, in the claim statement, I say, yes, they did supply more material, but they did not complete the project. They did not complete it on time. Therefore, my steel power plant could not start for the time period that I was waiting for the air-cooled condenser system. Therefore, I am entitled to damages. That was my case. Now, my lord, my respectful submission is the first error of the arbitral tribunal pertains to this date at page 142 of 30th of August 2011. It is not in dispute, my lord, that the contract did get extended up to 30th of August 2011. My respectful submission, my lords, is that the Honorable Tribunal should have inquired whether as of this date, the respondent completed the job. If the respondent did not complete their part of the work as on this date, they were in breach and I was entitled to damages. My respectful submission, my lords, is that this inquiry has not been done at all. Because, my lords, the Honorable Tribunal proceeds on a legally incorrect premise that
Time was not the essence.
time was not the essence. That finding, my lords, your lordship will please find at para 38, page 151. According to the respondent, he did not abandon the work, but stopped the work for non-payment of value of goods supplied and services rendered in spite of repeated requests and reminders. But according to the claimant, the respondent had abandoned the work. In effect, the work was stopped from 4/1/2012. The fact that the claimant got the remaining work of erection and commissioning of ACC system through some other agency is not seriously disputed by the respondent.
Yes.
Now, this is my first submission, that because the Honorable Tribunal comes to the conclusion that time is not of the essence, the Honorable Tribunal does not pose the correct question, which is, was there a breach as of 30th of August 2011? And therefore, my lords, does not answer it. For that, my lords, may I rely on section 55 of the Contract Act? And my lords, this was a point that was made before the Commercial Court. I will also point out, my lords, how the Honorable Commercial Court, in my respectful submission, erred in considering this. Section 55, my lords, in 3 parts. When a party to a contract promises to do a certain thing at or before a specified time, or certain things at or before specified time, and fails to do any such thing at or before the specified time, the contract or so much of it as has not been performed becomes voidable at the option of the promisee, if the intention of the parties was that time should be of the essence of the contract. If it was not the intention of the parties that time should be of the essence of the contract does not become voidable by the failure to do such thing at or before the specified time, but the promisee is entitled to compensation from the promisor for any loss occasioned to him by such failure. I, my lords, rely on second part of section 55, because the Honorable Tribunal's finding is time is not of the essence. With utmost respect, my lords, I cannot seriously question or dispute that finding. In those circumstances, I am entitled to compensation from 30th of August 2011, because that was the last date that was fixed by the parties.
According to you, there is no further extension of time.
There is no further extension. In fact, that's why, my lords, I began by reading that paragraph. That paragraph records the earlier extensions of time, which I don't dispute. The original date, my lords, if your lordship will please see, page 142, the original date was 9/5/2011, which got extended initially to 31/5/2011, and then ultimately to 30th of August 2011. So there were extensions of time which were mutually agreed, but after this, there is no written extension of time. Now, my lords, my respectful submission is, in law, I am not required to ask them to leave the premises. I can tell them, please go ahead, but that comes at the risk of me being entitled to claim damages.
What are the other materials that are supplied?
Lord, they have
According to
supplied, Lord, say, vast majority of the material, except, Lord, what is called an ejector nozzle, which was essential for commissioning. Is not disputed that I got it done through some third party, because despite many attempts by both parties to resolve this impasse, the impasse could not be resolved. That is not in dispute. That I got it done through a third party, and my plant got commissioned because I got it done through a third party. Now, my lords, my second submission, please, my
Yes.
second submission, the utmost respect, is that there is no categorical reason set out in the entire award as to who brought about this delay. The finding is both are responsible for the delay. My lords, that's a finding, that's a conclusion. The question that I ask myself, my lords, is where is the reasoning? For instance, my lords, page 150, para 35 of the award.
Yes.
Lords, about 7 lines above para 36.
Yes.
We have carefully gone through each and every email exchange between the parties from time to time, and we are of the opinion that delay is not attributable to respondent, but but attributable to the claimant also. My respectful submission, my lords, is that this finding is not supported by an examination of the evidence in light of the stipulations under the contract. Lords, my respectful submission is when there is a question of who caused the delay beyond 30th of August 2011, what were the obligations that I did not perform? What were the obligations that the respondent did not perform? And what were the obligations stipulated under the contract upon each of the parties? These should have been the subject matter of discussion. My respectful submission, my lords, is that conclusions are no doubt there, but the reasons for those conclusions are not found.
What was the finding of the commercial court on that?
Now, the Honorable Commercial Court on this point, in my respectful submission, incorrectly holds that this is a question of fact, and therefore the Commercial Court cannot go into this question. Your Lordship may kindly see, my lords, 2 paragraphs where the Honorable Commercial Court deals with this point. Running page 93, if your Lordship may please come to.
Yes.
Therefore, the claimant cannot escape the admitted liability to pay the due amount on the ground of delay in the work. This is because, as already noted supra, arbitral tribunal has recorded specific finding that time is not of the essence of the contract, and also recorded the finding at paragraph 50 that oral documentary evidence placed on record on behalf of both parties clearly shows that the claimant may delay in approving P&I drawings, cause delay in preparing civil foundation work as per approved P&I drawings, and fail to pay prompt amount claimed in the invoices raised on flimsy and untenable grounds, which made the respondent to stop the work. This is reference to para 50. Then on the next page, your Lordship will please find in the portion that is in bold a reference to paragraph 40. 2 paragraphs of the award have been referred to. My respectful submission, my lords, is both para 40 and para 55 no doubt present a conclusion. But my lords, my case is that the conclusion is not appreciated in light of the contractual stipulations and in light of the obligations of both the parties. May I request, my lords, your Lordship for a moment to kindly see the contract, because there could have been
No, thank you.
Lord, contract, your Lordship will please find at page 117.
Yes.
This is the letter of intent. If your Lordship will please see, my lords, clause number 8, 20% advance against ABG for like amount. ABG shall be issued by any nationalized bank, buyer's format, 70% with full T&D on progressive pro rata basis as per approved billing and dispatch schedule, and against submission of inspection clearance and pro forma invoice prior to dispatch, 10% immediately after commissioning and submission. Likewise, my lords, erection, 10% immediately on mobilization, 80% on submission of progressive pro rata monthly running account bill. Therefore, my lords, my respectful submission is that the Honorable Tribunal should have considered this delivery schedule, whether they delivered their goods on time, whether they raised their corresponding invoice, and after having received the invoice, did I not make the payments? And all of this prior to 30th of August 2011. My respectful submission, my lords, is that in the award, This analysis, with utmost respect, is not found. Conclusions, no doubt, are found. The second, my lords, is apart from payment, did I, for example, cause any delay in handing over the site to them? There should be a finding on the basis of some evidence, written, oral, such as it is, that I caused delay of so many days. With utmost respect, my lords, that finding is not there. And with respect, my lords, that finding is not there because the arbitral tribunal proceeds on the incorrect legal premise that once time is not of the essence, then the parties could have performed the contract at any length of time. That, my lords, with utmost respect, is a shocking conclusion because it could mean they could have performed it after 5 years also. There was indeed a cutoff date. That, my lords, is my first submission. My second submission, my lords, is I raised the point of limitation. I raised it, my lords, before the commercial court. I did not raise it before the honorable tribunal. It is also, my lords, a fact that I raised it before the commercial court at a later point in time by making an amendment application. That amendment application, my lords, was rejected by the honorable commercial court, against which I filed a writ petition. And, my lords, in the writ petition, this honorable court was pleased to allow me to permit to make the amendment application. Consequently, my lords, I was allowed to raise grounds of limitation. Lords, there my first submission is the honorable commercial court has pronounced findings of fact with regard to whether a set of documents will or will not constitute an acknowledgement within the meaning of section 18. Lords, the first question that I ask myself is, should the honorable commercial court have pronounced those findings of fact, or was the honorable commercial court required to set aside the award so that those findings of fact will nonetheless be pronounced by the arbitral tribunal? Because, my lords, in other places, the honorable commercial court holds that I am not a fact-finding court. I bow down to that principle. Second, there, my lords, on limitation, I have 4 grounds. It is not in dispute, my lords, that they walked away from the premises on 4/1/2012, 4th of January 2012. There is also, my lords, a correspondence of September 2011, a minutes of meeting, which is held against me. September 2011, my lords. I'm sorry, September 2012. The counter claim is filed in October of 2015.
Yes.
Therefore, my lords, and my lords, interest is awarded in the award from 4/1/2012. The award, therefore, my lords, holds that the date of breach is 4/1/2012. This is in the award. Then, my lords, I asked the question to myself, should the limitation not have stopped? Should the clock not have come to an end on 4/1/2015? And admittedly, the counterclaim was filed in October of 2015. To this, my lords, a multifarious answer is set up by the respondent, which is, the first submission is that the correspondence of September 2012 amounts to an acknowledgement. But even if it did amount to an acknowledgement, that would still not save the period of limitation because this is October. Therefore, my lords, only 2 documents need to be seen, which is, I issue, my lords, an arbitration notice to which they issue a response. Whether that response can be construed as stopping the clock of limitation running. On that, my lords, your lordship may only kindly see the finding of the honorable commercial court. The finding, my lords, your lordship will please find at page 105.
Yes.
At page 105, my lords, in para 25, the honorable commercial court says that I have, in the third line, my lords, having considered the various rival points with regard to limitation in respect of counterclaim, one point which cannot escape the notice of the court and which according to me is decisive is that in the claim petition, there is a categorical admission that the amount is payable to the respondent. On this count, my lords, this is one reason why the Honorable Commercial Court finds against me that there is an admission by me in the claim petition. In my respectful submission, my lords, I will read that paragraph. That is a very, very unnatural reading of the claim petition. And it was not the contention of the parties either. This is, my lords, one finding, that in the claim petition, there is an admission.
Yes.
The second finding, my lords, the Honorable Commercial Court comes to the conclusion that this Honorable Court may kindly see page 115, para 33.
Yes.
Lords, in the middle of the page, there is reference to section 21 and a particular dispute.
Mm.
Lord, the contention was that when a reply is issued to my arbitration notice, that reply does not constitute a notice within the meaning of section 21 of the Arbitration Act, having the effect of stoppage of limitation. The Honorable Commercial Court, my lords, does not answer that point and merely says the reply should be liberally construed at page 116. In my view, the said reply should be liberally construed. Lords, the question is, my respectful submission is, this finding is contrary to section 21. May I just read that one document, my lords? But if your lordship will please kindly see this one document at page 68 of the memo of documents, my lords. This is the reply to my notice.
Yes.
It also says, so my lords, it is the response is to my advocates. Subject, that is reference, reply to your notice dated so and so as modified by notice dated so and so. This has reference to your above referred notice dated so and so as modified by your subsequent notice dated so and so. Our client has handed over to us copies of the said notices. A copy of the said notice dated so and so has also been marked to us. Our client has since instructed us to reply to the said notice as follows. Your said notice under reply has been issued by you under wrong advice from your client, and the same contains false and frivolous allegations made against our client. Please note that our client denies all allegations. Then third paragraph, my lords, your client pursuant to a letter of intent dated so and so assigned to our client the work of supply, erection, commissioning. Our client has duly mobilized his men and machinery at the site and completed a substantial part of the contract. In terms of the said letter of intent and assignment given, our client had time to time raised invoices upon your client, but your client have failed and neglected to pay the outstanding amount. After giving adjustment of all sums paid by your client in part on so and so, a sum of rupees 1.47 crore is still due and payable by our client. Our client has on several occasions called upon your client to make payment of the said outstanding dues. In spite of the same, your client failed and neglected to make payment. We, by our letter dated so and so, written on behalf of our client, called upon the client to pay outstanding dues along with interest at 18%. The said notice was also a statutory notice under 434 of the Companies Act 1956. Since in spite of demand, your client failed and neglected to pay the said outstanding amount along with interest, our client filed an application under 433 of the Companies Act, being company petition number so and so, in the Honorable High Court of Delhi at New Delhi, and the Honorable High Court is in session of the matter. Without making payment of the outstanding dues of our client, your client, by your said notices under reply, are now trying to make out a false and frivolous claim of rupees so and so, and also for a client's selfish gain. Such claim by your client are absolutely baseless and arbitrary. During the pendency of the said company petition before the Honorable High Court of Delhi, your client is purporting to invoke the arbitration clause of the said letter of intent, and your client has proceeded to name Shri R.M. Vaidya, retired district and sessions judge, as a sole arbitrator. Please note that without prejudice to our client's rights and contentions in the pending winding up proceedings before the Honorable High Court of Delhi, our client objects to the appointment of Shri R.M. Vaidya as the sole arbitrator and names Shri H.M. Bhartesh, retired principal and district judge and former principal secretary, so and so, as the sole arbitrator to adjudicate the dispute between our client and your client. Please note that this reply is issued by us on behalf of our client without prejudice to the rights and contentions in the pending company petition. The question therefore, my lords, that fell for consideration was whether such a reply can constitute invocation of arbitration within section 21 of the Arbitration Act, because section 21, my lords, uses two particular phrases. A particular dispute commence on the date on which a request for that dispute to be referred to arbitration is received.
Yes.
My respectful submission, my lords, is that this notice does not amount to reference of their dispute, because they only preserve their rights and say, I will continue to prosecute my company petition before the Honorable High Court of Delhi. Without prejudice to that company petition, because you have made a reference, I am also making a reference. In my respectful submission, my lords, on this, there is no answer. Therefore, my lords, and they have filed execution, they have moved the execution. It was listed last week. 50% of the award amount has already been deposited by me before the Honorable Court. But if the records are called for, these are the principal points.
I can respond in detail to every one of my learned friends' allegations. My learned friend should have first of all brought to your lordship's notice what was the nature of the dispute before the arbitral tribunal. It was not a claim for recovery of money per se. Their contention was that they engaged my services. I did not perform in time. Therefore, had this ACC system been installed and their power generation started, they would have saved money or earned money to an extent of about 30 odd crores. And because that did not happen, it was a claim for damages. It was not a claim for money due. So first of all, the tribunal had to come to the conclusion whether they had established losses of 30 plus crores by my non-performance. That was the sum and substance of the dispute.
Yes.
They having filed the claim petition before the tribunal, I filed a counterclaim for recovery of money actually due. I had supplied goods and services. They admitted, as my learned friend just now did, they admitted the receipt of all the goods and a substantial amount of the services. There was a balance due. I made a counterclaim for the balance money due to me. My first submission of my learned friend was referring to para 47 of the award. That your lordship would find at page 154 of the appeal memo.
Yes.
Where my learned friend brought to your lordship's notice what was the nature of the job that I was entrusted to do. Para 48 is the answer. Why my counterclaim was made. The respondent had commenced the work and had completed admittedly supply of materials 100% and erection 90% and had raised invoice for 3 odd crores. Admittedly, claimant has paid 2 odd crores on different dates. Balance amount that was to be paid was 1.47 odd crores. Since claimant did not clear the pending bills in spite of repeated requests, the respondent stopped the work. The claimant, though, admits his liability to pay 1.1 crore 47 lakhs odd, he contends that he is not liable to pay 6 disputed amounts amounting to 33 odd lakhs. And if that amount is deducted from 1.47 crores, the amount actually payable by them would be 114 odd crores. And since they have spent 44,59,439 for completing the remaining work, that amount will have to be deducted from 114, and remaining amount liable to be paid by them is only 69 odd, according to claimant. Claimant does not want to pay even that amount also. Instead, claimant is claiming that it had invested more than 282.9 crores for building an integrated steel plant for the manufacture of pig iron by borrowing money from various financial institutions, and had kept the steel plant idle because of non-commissioning of ACC system by the respondent, and hence it is entitled for interest loss and profit loss amounting to rupees 33 odd crores. So the fact of the matter is, I stopped the supply because I was no longer being paid. He says, because you stopped the supply, I could not commission the plant, etc., etc. Clear-cut admission that 1.47 odd crores was due to be paid by them, but they started setting off various items against it. The Honorable Arbitral Tribunal has considered all these facts and as against my claim of about 1.47 crores, your Lordship will find at page 166. The tribunal has not awarded me the full amount that has been claimed. It said, yes, justly there are some set-offs which are justified by the claimant, that is the appellant before your Lordship, and awarded me only a sum of 1.11 crores. That was done only after a fairly detailed examination of the facts. If there was no examination of the facts, the tribunal could have simply said 1.47 crores claimed, 1.47 crores awarded. To reduce it to 1.11, there had to be a fairly substantial, what we call examination of the facts and documents produced. The next contention that my learned friend had brought forth was also they had to engage a third party, which I had also just now read, that 45 odd crores they spent on a third party. This, the tribunal has already come to the conclusion at para 58 of the award. Page 159. On the so-called third party having been engaged and therefore money spent.
Yes.
Para 58, page 159. We have come to the conclusion that claimant was due in a sum of rupees 1.47 crores in August 2011. Since claimant failed to pay the said amount, the respondent has stopped work on from 4/1/2012. According to claimant, if erection and commission of so-and-so was complete, then would have been liable to pay 1.47 crores. Claimant's oral and documentary evidence is not sufficient to hold that the claimant is not liable to pay 25,57,000, which was disputed amount in respect of 5 items. The oral and documentary evidence adduced on behalf of the claimant is not sufficient to hold that the claimant is not liable to pay certain deductions regarding short supply, etc., amounting to 7.5 crores. It is the further case of the claimant that they have spent rupees 44,59,439 to complete the project. In the cross-examination, PW1 has admitted that he has not produced any document to show that the claimant has spent rupees 44,59,439 to complete the project. The claimant could have examined the agency through whom they have completed the project to show that they have spent 44 lakhs, etc., to complete the project. They have not chosen to do so for the reasons best known to themselves. Therefore, in the absence of oral or documentary evidence, we have no hesitation to hold that the claimant has failed to show that they have spent 44,59,439 to complete the work. That completely answers two of the very substantial submissions made by my learned friend. As far as limitation was concerned, my lords,
Detailed evidence list. Evidence given.
yeah. As far as limitation was concerned, my learned friend relied on, first of all, Section 21 of the Arbitration and Conciliation Act, especially with reference to the notice and reply notice sent by them. We refresh our memories, my lords, by just reading Section 21 of the ANC Act. Unless otherwise agreed by the parties, the arbitral tribunal proceedings in respect of a particular dispute commence on the date on which a request for that dispute to be referred to arbitration is received by the respondent. Now, my learned friend read his legal notice that your lordship would find at the paper book just now submitted at page 400.
Meeting.
This legal notice was sent only on 20th of December 2014. Our client so-and-so has instructed us to send notice to you invoking arbitration clause 8 of letter of intent dated 9/7/2010 and to inform you that we're nominating so-and-so, so-and-so, so-and-so. We had been instructed to issue notice quite some time back, and at the time of issuing notice, certain facts were not properly highlighted since there was a gap between instructions and preparation of notice. Therefore, we hereby withdraw the notice dated 18th December 2014 issued on behalf of our client, and the same may be treated as withdrawn. Then, this particular notice, they make their claim where they specifically refer to the fact that we had already issued para 1, we had already issued a demand against them. Our client disputes and denies all the contentions allegations in your notice dated 13/5/2014. It is not as if for the first time that my reply to this particular notice, my claim was made. I had already issued a notice on 13/5/2014, wherein you demanded a sum of 2 crores 20 lakhs and demanded the said notice be treated as a statutory notice and so on so of the Companies Act. Then, if your lordship goes to the next page at 402,
Yes.
para 4. In view of the above mentioned facts and circumstances, our client hereby invokes clause 8 of the LOI, arbitration clause, to invoke arbitration to determine the aforementioned claims and disputes and all other disputes that may arise in the arbitration in furtherance of the same. Our client so-and-so nominates so-and-so. So this is the first salvo of theirs in December 2014 under section 21. A request for that dispute to be referred to arbitration received by me. It is to that a reply has been sent at page 403, which my learned friend has already read to your lordships, that in the last paragraph of page 403, we once again say that after getting adjustment of all sums paid by your client in part as on 30th April, a sum of rupees 1 crore 47 lakh was still due and payable by your client. So the starting point for limitation is the date on which a request has been made by them and received by us. Even if you take the date of request, 20th December 2014, they filed the claim statement. And as your lordship will see from the list of dates and events produced by them, along with the memorandum of appeal, they themselves at page 6, item number 41. Respondent number 1 filed the statement of defense and a false counterclaim, which was barred by limitation. So they admit my counterclaim was filed in October 2015. The reference to arbitration is sought only in December 2014.
Yes.
Less than 10 or 12 months later. So that's the only facts that I would like to counter as far as the admission of the appeal, my lords, is concerned. Ultimately, the admission of the appeal may, my learned friend may say, may require a more detailed examination. I leave it to your lordships. Insofar as the application for stay is concerned, they sought a stay before the commercial, in the trial court when they filed their section 34. Pursuant to that, they deposited a sum of 50 odd lakhs by DD before the trial court. Now they have sought a stay in these proceedings. My calculation is as far as now interest was awarded at 18% per annum. As of today, the principal and interest amount due from them is about 3.51 crores. My learned friend may counter us by saying that even the award of interest at 18% is under challenge by me. The interest component is about 2.4 crores. Even assuming he says that's a subject matter of challenge, and we even reduce it by 9%, it still amounts to about 1.2 crores. If your lordships are inclined to stay the award, they may be directed to pay at least 50% of the total principal and interest. Yes, as a matter of fact, under CPC, that provided if the decree is one for payment, for find its records for so doing. And as it stay the execution until the pending suit has been decided. And I think under that thing, under the Commercial Courts Act is where this thing is. No? Anyway, whatever it is, I mean, there's a substantial amount due from them. They want stay of the execution. I leave it to your lordships. And my learned friends, negotiation powers to see how much has to be deposited.
Two submissions then.
Yes.
In 2018, I have deposited 55.68 lakhs already, 50% of the award amount. Therefore, my lords, to that extent, my bona fides have been shown then. Therefore, my lords, even in respect of that amount, interest will stop running against me altogether because I had deposited it. Substantial point on limitation is raised. But it may be heard at an early date. 50% of the principal amount has been secured 6 years ago. And my lords, I had a claim, a substantial claim, which has been rejected. And my lords, on limitation, if what my learned senior argued is correct, then my lords, on law, straight away their counterclaim will go because State of Goa versus Praveen Enterprises, Supreme Court, my lords, has held that the period of limitation for a counterclaim will usually begin on the date of the counterclaim and not on the date on which I have invoked the notice or I have filed my claim, except where they refer the matter, that is the respondent refers the matter to arbitration, which, my lords, in my respectful submission, that is not a reference. Therefore, in my respectful submission, my lords, I do have an arguable case. That, my lords, I leave with your lordships.
CH-3. 36-3.
Yeah.
On acknowledgement of it is a settled loan. That's all right. It is that discussion. Hope of interventionist. Public policy. Final hearing in due course. And by then you will also become a senior.
Now the contention is that the claim that
that money has to be kept in the fixed deposit.
Tribunal and council on either side call for the records, the commercial court lists for hearing. Nobody else is to be served.
No.
List for the staff to month. Yes. My brother is of the opinion that since 50% has already been deposited, the amount is kept in
No, that's not been kept in fixed deposit, unfortunately.
in view of the.
But
fact
that's only
that
50% of the principal at that time, my lord.
Only 50% of the principal is.
55 lakhs.
Amount. Let them deposit
55
the balance of
lakhs.
the principal.
50% of the award amount.
Yes. Or
The amount.
that includes 18%. Yes. Fix it. National.
Yes, there'll be a stay of further proceedings in the execution till the next stage of hearing, in condition that the appellant remits 50% of the award amount before the execution court within 4 weeks.
Please.
The amount so deposited, along with the amount deposited earlier before the commercial court, shall be kept in a fixed deposit with auto.
Lord, the execution is filed in Delhi. Therefore, if your lordship permits me, I will deposit the amount before the commercial court in Bangalore because the previous amount has been deposited here.
Yes, the commercial court.
kept in fixed deposit. Earlier it was not kept in fixed deposit.
Amount
Yeah.
as well as the amount earlier.
Earlier and present amount. and-
Yes, shall be kept in fixed deposit with with, yes, auto renewal mandate.
Great.
Yes, list after month.
March. Great.
Number 3, Aniket VC.
Similar for the respondent matter. Plaintiff is, this is plaintiff's appeal. Plaintiff is a manufacturer of rubber chemicals and other raw materials.
Yes.
Submission, madam. One submission, madam. I have raised an objection regarding maintainability of the appeal. Submission is that appeal is not maintainable. Yes, to file a. petition.
What is the appeal against?
Appeal against order 38 rule 5 of the CPC. Attachment before judgment application came to the dismissal.
38 or rule 6? What is the order?
Order 38 rule 5, my lord.
What is the
The
order which is under?
application came to be dismissed, my lord. And against that particular order, my lord, no appeal is provided under order 43 rule 1, my lord.
That has been considered at the.
Yes, yes, my
last
lord. I
date.
argued that aspect on 9th of
Yes.
July. This honorable court considered and
Before
overruled.
issuance of notice, it appears to be considered, my lord. And thereafter, this court has kept that particular objection in abeyance and notice has been issued.
Just
And,
a minute.
I have-
I'll convince my lord.
Yes. For the time being. Yes, yes,
And order said for the time being.
yes, it says for the time being.
Yes, yes.
Yes,
My lord, now, section 13(1)(a) of Commercial Courts Act says,
yes,
13(1)(a), any person aggrieved by the judgment or order of a commercial court at the level of a district judge exercising original civil jurisdiction, or as the case may be, commercial division of high court may appeal to the commercial appellate division of that high court within a period of 60 days from the date of judgment or order. Proviso is more important. Provided that an appeal shall lie from such orders passed by a commercial division or a commercial court that are specifically enumerated under order 43 of the Court of Civil Procedure 1908. Therefore, my lord, if an appeal lies under order 43, no, my lord, if my lord can take order 43 rule 1 of CPC.
yes,
Order 43 rule 1,
yes,
my lord, order 43.
Mm.
My lord, Q.
yes,
In the beginning, an appeal shall lie from the following orders under the provisions of section 104, namely
3
Q.
or 6.
Yes, my
2,
lord.
3 or 6.
2, 3 or 6. Now the question is whether this falls in an order under order 38 rule 3 or 6.
Correct.
2 and 3 do not apply because they are for arrest before judgment. Therefore, whether it falls under order 38 rule 6. No, my lord. Order 38 rule 5 says where defendant may be called upon to furnish security for production of property. 1. Where at any stage of a suit, the court is satisfied by affidavit or otherwise that the defendant, with the intent to obstruct or delay the execution of any decree that may be passed against him, A is about to dispose of whole or any property, or B is about to remove the whole or any part of his property from the local limits of jurisdiction of the court may direct the defendant within a time to be fixed by it, either to furnish security in such sum as may be specified in the order, to produce and place at disposal of court when required, the said property or value of the same, or such portion thereof as may be sufficient to satisfy the decree, or to appear and show cause why he should not furnish security. 2. The plaintiff shall, unless the court otherwise directs, specify the property required to be attached and estimated values thereof. 3, the court may also in the order direct the conditional attachment of the whole or any portion of the property specified. 4, if an order is not passed without complying provision so and so, such a attachment shall be void. No, my lord. In this case, what had happened was, I filed a suit. It came up for hearing before the court for the first time on 20th of February 2023. Annexure D I have produced. On 20th of Annexure D, my lord, ink page number 160, if your lordship goes to.
Yes.
Last entry, my lord, it's in typewritten form, 20th February, plaintiff counsel present,
Hmm.
heard learned counsel Shri ABC on IA 1 and 2. Considering the urgency in pursuance of his plaintiff has moved an application under order 38 rule 5, application filed by plaintiff for dispensation is allowed. Then, my lord, I'll not read it now because I'll have to read it on merits, my lord. I don't want duplication. That's why I'm not reading. If my lords goes to operative portion of the order at ink page 162, I'll read this order again, my lord, by satisfying this court on merits. Charge is created in respect of other items of plain scheduled properties except properties already sold by defendant 2 under 2 different sale deeds dated 30th December 2022 and 9/1/23 till next date. No, my lord, an order is passed under order 38 rule 5. I say rule 5 1 clearly says it can be passed, be that as it may, I'll get into that. No, my lord, after this, the defendants entered appearance. Defendants have filed written statement, my lord, which is at Annexure E, page number 164.
Yes.
And my lord, they filed objections to IA at Annexure F at page 171.
Yes.
After that, my lord, the Land Trial Court has passed an order at Annexure A on 10th of June 2024. Now, my lord, therefore, from paper it is clear that interim order was passed. Defendant entered appearance. Now, what should happen in that scenario, my lord? For that, we'll have to see Order 38, Rule 6 of CPC.
Yes.
Because 38 Rule 5, as your lordship saw, does not say anything about what should happen after the defendant appears. It only is spoken in Order 38 Rule 6. Application is nevertheless under Order 38 Rule 5. 38 Rule 6 is attachment where cause not shown or security not furnished. Where the defendant fails to show cause why he should not furnish security or fails to furnish security required within the time fixed by the court, the court may order that the property specified or such portion thereof as appears sufficient to satisfy any decree which may pass in the suit be attached. This is not attachment. But what happens if cause is shown? 2. Where defendant shows such cause or furnishes required security and the property specified or any portion of it has been attached, the court shall order the attachment to be withdrawn or make such other order as it thinks fit. Now, my lord, what has the trial court done is by Annexure order, it has dismissed my application for virtually withdrawing the attachment order. Therefore, my lord, this is an order passed under Order 38 Rule 6 Sub Rule 2, although on an application under Order 38 Rule 5. Therefore, it is clearly appealable under Order 43 Rule 1Q, which talks about Rules 2, 3, and 6.
Upon these facts, I need to consider the opinion that no justified grounds have been made out by the plaintiff at this stage. The attachment of the scheduled property as per accordingly answered. Yes.
Therefore, in my submission, my lord, appeal is maintainable, all 3 writ.
What would you say on the maintainability?
Yes, ma'am. My submission is that, my lord, may, I request my lords to once again consider the Order 38 Rule 5. I will not read it, but request my lords to consider it.
Yes.
This Order 38 Rule 5 Sub Rule 1, my lord, it requires satisfaction of the court at 2 stages. 38 Rule 5 1, my lord.
Yes.
Where at any stage of the suit, the court is satisfied by affidavit or otherwise that the defendant with intent to, so the court has to satisfy whether I have an intention to obstruct or delay the execution of any decree that may be passed against him, is about to dispose of the whole or any part of his property, or is about to remove the whole or any part of his property from the local limits of the jurisdiction of the court. So this is one satisfaction, my lord, with respect of I am about to dispose of all my property, not one particular property, all property. and I'm removing with an intention to defraud. So that is the satisfaction. Then, my lord, the court may direct, this is the direction, my lord, the court may direct the defendant within a time to be fixed by it. So they have to fix a particular time, either to furnish security in such sum as may be specified in the order, to produce and place at the disposal of the court when required, the said property or the value of the same or such portion thereof may be sufficient. This is sufficient to satisfy the decree or to appear and show cause why he should not furnish the security. So, my lord, this is the first stage. It is an ex parte order. Then, my lord, there is sub-rule 2. I will not read it, my lord. Sub-rule 3 empowers the court to pass an ex parte order, my lord. Sub-rule 3, it reads like this. The court may also, in the order, direct the conditional attachment. It is not a complete attachment. It is a conditional attachment of the whole or any portion of the property so specified. So this was in the unamended prior to 1976. These are the provisions, my lord. Then, my lord, a particular sub-rule has been added. That is sub-rule number 4. It says that, man, if an order of attachment is made without complying the provisions of sub-rule 1, compliance means satisfaction of the court.
Compliance with sub-rule 1 means.
Yes, my lord. It is an ex parte order, my lord.
The issuance of the notice.
Yes, my lord. Issuance of the notice. Then, my lord, there is an appendix F is there, my lord. Appendix
Court
F
may
says,
direct defendant within a time to be fixed by it, either that is the direction by the court to furnish security in such sum or to produce and place before at the disposal of the court when required said property, etc.
yes, ma'am. So
Yes.
it is a satisfaction what
If, as a matter of fact,
yes,
an order of attachment is passed without issuing such notice at all, it would be void.
my submission is that, my lord, my submission is that the court, when exercises its jurisdiction under order 38, rule 5, sub rule 1, it is a tentative order. It is not a final order.
Correct.
Once I appear, once I file the objection, once again, the court will satisfy itself whether it could have, whether it is supposed to exercise its jurisdiction under order 38, rule 5, sub rule 1.
Then what is the need of having a provision as sub rule 6 2 at all?
The sub rule 3 is a conditional attachment.
I understand.
Yes, yes,
3 is a conditional attachment.
yes,
Now, if what you're saying is correct,
yes, ma'am.
then all that is required is 38.5.
Yes,
Then the whether it was the conditional attachment should have been passed or not is also being considered under 38.5. Then
Yes.
what is the need for 38.6.2?
yes, ma'am. The 38 rule 6 is a situation when the court call upon me to show whether you are capable of furnishing the security. That is the next stage. And in the event if I fail to furnish the security or show cause, because it words, the 38 rule 6 uses the word failure.
You have been issued with notice.
I have not been issued the appendix F attachment in this case.
That is not required.
That is what contemplated in this particular proceedings, my lord. My submission is that, my lord, I request my lords to kindly take appendix F, and the court specifically has also not issued the attachment warrant. The court, when exercising its jurisdiction, my lord, it is also supposed to issue an attachment warrant also. That is specifically provided in appendix F, supplementary proceedings, form number 5. The exercise of discretion under order 38 rule 6, the compliance is totally different. That is the next level. That is the next stage. Because I am supposed to be called upon. Once I was specifically directed to furnish the security. In the event of my failure to provide the security, my lord, then the court.
Furnish the security or show cause.
Yes, ma'am. Yes, ma'am. I
Either
have to show cause.
So
Or
you
I
show
can,
cause.
I can bring my friend, my lord, as a surety. That is the next
Correct.
form number 6.
No,
And he
but-
will stand as a surety for me.
In this case, you appear and show cause.
No, that is not the stage, my lord. I have filed my objection and the court has satisfied. Thereafter, the court has revisited once again to the stage of order 38 rule 5 sub rule 1, and the court has come to a conclusion that he has not made out any ground. He has not made out any case to exercise the jurisdiction under sub rule 1.
Your contention is that it is not under 38.6 at all.
At all. That stage we have not reached. My lord, there are two decisions, my lord, the single judge decision of this honorable court, my lord. I will just place those judgment on record and it specifically says that appeal is not maintained. Thank you. First of the point.
Thank you.
My lord, the first decision, my lord.
Yes.
Judgment, my lord. It is of the year 1976, my lord. Sorry, 73. It was prior to amendment, my lord, prior to 1976 amendment. But the court has taken into consideration of sub-rule 1, 2, 3, my lord. Thereafter, the court has rendered its judgment. I request my lords to permit me to read this judgment, my lord, because it is only one page judgment.
Yes,
The defendant is the petitioner, my lord.
yes.
The revision petition is filed, the revision was filed, my lord. Is directed against the order made for the attachment before, in OS number so and so, for recovery of certain sum of money. The operative portion of the order made by the trial court reads as under. It is in the result, it is hereby ordered and directed that defendant shall furnish security to a sum of rupees so and so on or before 10th August 1972. If defendant will fail to furnish the security on or before that date, attachment to issue as prayed for by the plaintiff. That is the order, my lord. So that particular order comprises two parts, my lord, that has been explained and read. Against the said order, the defendant filed an appeal before the principal civil judge, Bangalore City. The learned civil judge has held that appeal was not maintainable before him. Aggrieved by the appellate order, this revision petition has been preferred. It is not in dispute that if an order is made under Rule 5 of Order 38 CPC, no appeal lies against it. But if the order is made under Rule 6 of 38, an appeal is specifically provided under Rule 1 of Order 43 CPC. Therefore, I have got to see whether the order of trial court falls under Order 5 or Rule 6 of Order 38, or it is an order under both Rule 5 and 6. The first portion of the order of the trial court evidently falls under Rule 5 because it is an order directing the defendant to furnish the security on or before 10th August 1972. But the later portion, if the defendant will fail to furnish security on or before that date, attachment to issue as prayed for the plaintiff by the plaintiff certainly falls under Rule 6 of Order 38 CPC. Therefore, it seems to me that the order of the learned Munshi was an order made both under Order 5, Rule 5 and Rule 6 of the 38. The learned civil judge was therefore wrong in holding that the order was not appealable. But the difficulty still remains whether an appellate court in an appeal preferred against an order made both under Rule 5 and 6 of Order 38 could go into the merits of the orders falling under Rule 5 of Order 38, in as much as no appeal lies against an order passed under Rule 5 of 38. In my view, when an appeal does not lie against an order made under Rule 5 of 38 CPC, the appellate court has no jurisdiction to go into the correctness or the validity of that portion of the order. But the appellate court could pronounce upon the validity or correctness of the order falling under Rule 6 of Order 38 CPC. My lord, my submission is that, my lord, taking clue from this particular judgment, what is included before my lords is not the ex parte interim order earlier passed. What is included before my lords is an order passed under Order 38 Rule 5 dismissing his application. When there is a dismissal of his application without going to the next stage, calling upon me to furnish the security and my failure, my lord, my submission is that appeal is not maintainable. Next, my lord, the same judgment has been followed post 1976 amendment, my lord. I request my lords to kindly take Palghar Rolling Mills, my lord.
Yes.
Yes, my lord. Here, my lord, in that particular case, as a precaution, my lord, an ex parte attachment before judgment was passed, exercising jurisdiction under 38 Rule 5 sub Rule 3, my lord. Then, my lord, as a precaution, that particular person had preferred, the defendant had preferred both appeal as well as revision. And it was before the single judge only, before the same single judge. Then, my lord, the court has considered. I request my lord to kindly take the judgment starts at page number 3993, my lord. My lords, look into the para number 1, my lord. The reference is given with reference to MFA as well as revision petition. The contents of the order has been explained in para 2, my lord. I request my lords to permit me to read para number 3, my lord. The court below, after hearing the plaintiff's counsel, issued ex parte order of attachment of movable under order 38 rule 5. The defendant number 1 being aggrieved by the said ex parte order of attachment of movables initially filed a miscellaneous appeal. However, as a matter of precaution and in view of ruling reported in Narayan Rao versus Kasturi, just now I read, the defendant 1 filed the revision also. Hence, both the matters have come up for hearing today. The learned counsel for so and so contended that order of attachment before judgment passed on so and so was in violation of the mandatory requirement laid down by order 38 rule 5 CPC. According to him, it was an order passed by the court below without jurisdiction. Then, my lord, there is an extract after the order is there, my lord. Then I request my lords to kindly take next page, my lord. The court has extracted order 38 rule 5 at para number 7, my lord. And they have specifically referred to the amendment, which was by which there is an insertion to sub rule 4, my lord, in para number 7. Then para number 8, they start discussing with the provision, my lord. Para number 8, page number 39951.
Yes.
The mandatory essentials of order 38 rule 5 are: the court must be satisfied by affidavit or otherwise that the defendant with intent to obstruct or delay the execution of the decree that may be passed against him is about to dispose of the whole or any part of his property, or is about to remove the whole or any part of the property from the local limits of the jurisdiction of the court. Therefore, the most essential requirement of order 38 rule 5 is the subjective satisfaction of the court regarding the requirements mentioned above. Order 38 rule 5, in my opinion, is a mandatory provision demanding of the court to satisfy itself that the defendant is intending to obstruct or delay the execution of the decree that may be passed against him. If the order passed by the court does not speak or show that the court has applied its mind to the requirement of order 38 rule 5, or if the order passed by the court below does not show clearly that it has considered the material on record, or if the court does not show that the court is satisfied that the defendant with intent to obstruct or delay the execution of any decree that may be passed against him is about to dispose of whole or any part of the property, the order would be in violation of order 38 rule 5. Order 38 rule 5, as it stood before the amendment in 1976, would have at the most rendered such order irregular. But now sub rule 4 inserted by section 85(1) of the Act 104 of 1976 reads that if an order of attachment is made without complying with the provisions of sub rule 1 of rule 5 of order 38, such attachment shall be void. Sub rule 4 has been inserted with a view to see that the courts do not pass such an extraordinary order in a cavalier manner and without satisfying themselves about the requirement of order 38 rule 5. Lord, my submission is that, my lord, since there is a specific insertion of sub rule 4, after once the notice is issued with reference to the IA for attachment, the court is required to once again revisit the order 38 rule 1 and has to satisfy itself whether it could have exercised its jurisdiction under order 38 rule 1, and it is a mandatory provision. It has to satisfy, it wants to obstruct.
It is created a charge. Thereafter, litigation was dismissed. Court is also possible. Court has moved. Court has created charge, not passed, order passed on, order 38.
Therefore, it is on the file itself, is it? Yes.
Yes, my lord. Then, my lord, the court at para number 11 has extracted
Hmm.
the warrant which was issued in that particular case, my lord. A warrant of attachment which has been issued.
Hmm.
Then there is a discussion regarding that, my lord. Then, my lord, at para number 14, the court considers the earlier judgment, my lord, at page number 4001.
Hmm.
Para number 14. The court comes to a conclusion that, my lord, an order passed under 38 rule 5 in that particular case where the defendant had preferred an appeal is not maintainable. The court came to a conclusion that, my lord, revision petition is maintainable and revision petition was considered on merits. We'll read para number 14. The learned counsel Srinivasan submitted that an appeal against such an order is not competent. This court has ruled in Narayan Rao versus Kasturi and others that an appeal against an order passed under order 38 rule 5 is not competent. Then, my lord, the court has dismissed the appeal and they have considered the revision petition. Lord, my submission is like this, my lord.
Yes.
In this particular case, my lord, if my lords take page number 42, that is the impugned order annexure A, the operative portion reads like this, my lord. The impugned order starts at page number 42, my lord. The reasoning starts at page number 47, para number 8, my lord.
Yes.
Then, my lord, para number 8, 9, 10, my lord, the learned judge discusses not with reference to order 38 rule 6. There is no discussion regarding the order 38 rule 6. The discussion is with reference to his satisfaction under order 38 rule 5. And then he says that he is an unsecured creditor. He cannot convert this into a secured credit and he cannot seek for the security. And therefore, my lord, various other aspects, he dismisses the application. There is no discussion regarding my failure or there is no discussion about calling upon me to furnish the security. So my submission is that the learned judge has not discussed, exercised his discretion under order 38 rule 6. So it is under order 38 rule 5, my lord. If my lords take order 43, expressly they have excluded order 38 rule 1. Order 38 rule 1 is with reference to issuance of arrest warrant.
Correct.
Then, my lord, he is supposed to provide the security. If he provides the security, acceptance or not, that is under order 38 rule 2 and 3. That is specifically incorporated. Whereas 38 rule 1 is not incorporated. Similar to that of, my lord, order 38 rule 5 has been specifically excluded. And order 38 rule 6 has been incorporated and appeal is provided. That stage we have not reached.
Yes.
May I please, my lord?
Just a moment. Here, any question?
My lord, in usual course, my lord, in usual course, we prefer, earlier we used to prefer revision petition. Now we are filing the writ petition.
But petitions have this LTU to be paid to the person that is concluded. And the defendant is attempting this one. There is something to pay. Yes.
My learned friend is bringing two stages in Order 38 Rule 5, one itself, which are not there, my lord. I'll point out how. My lord can see Order 38 Rule 5(3) once. The court
Yes.
the court may also in the order, my lord, I am emphasizing the word the order, because now the question is, let us read it again, my lord. It says in the order direct conditional attachment of whole or any portion of property so specified. Let us now for the time being forget about existence of Rule 4, my lord. Now, if we see the entire order, Order 38 Rule 5(2) does not talk about any order.
Correct.
Rule 38(1) talks about an order.
Correct.
It says the court may direct the defendant within a time to be fixed by it either to furnish security in such sum as may be specified in the order, to produce and place at the disposal of the court when required the said property, or the value of the same, or such portion thereof as may be sufficient to satisfy the decree, or to appear and show cause why he should not furnish security. Before 1976, what it said was, therefore, the court on being satisfied, either you call for security or say furnish security or show cause notice. There 3 said in the order under Order 38 Rule 1, Rule 5 Sub Rule 1, because the, as your lordship knows, is the definite article, which is the it is referring to. Therefore, said the court may also, and my lord, that's also important. It says also in the order. It doesn't simply, if it had said the court may order conditional attachment was the wordings, for example, then perhaps this argument could have been taken up. This clearly says the court may also in the order direct the conditional attachment of the whole or any property of this property so specified. Therefore, my lord, Sub Rule 3 of Order 38 Rule 5 clearly shows that what it meant was, along with the Rule 5(1) order, Rule 5(3) also order also could have been passed by the court. That was enabling the court. Now, 1976 amendment came. My lord, my argument is going to be on 4. I would have argued this on merits to say that in view of these wordings, this shall be void is only may be void. I have some reference to authorities on that point to just point out that a court cannot be helpless in a situation. And I will give example, my lord. In this case, I have filed a case on 19th of February 2014. 20th February, the court passed this order. I will produce, my lord, 22nd of February 2024, they filed 23. I'm sorry, 22nd of February 2024, they have filed a petition before the Honorable NCLT, where they have admitted that their liability towards me is 5 crore 3 lakh rupees. Whereas in this Honorable, before the commercial court, they appear and say, no, I paid the entire amount under, part of the amount is time bar, part of the amount I have. And my lord, why it is important is, somebody cannot say courts are so helpless that somebody comes to court. And it is not my fault, my lord, on the face of it, first of all. I did not say pass an order like this. The trial court, I will take your lordship through Annexure D order also as to whether the court below has applied its mind or not. But coming to interpretation of it, my lord, therefore, if Sub Rule 4, which was inserted later, was not there, Rule 3 order would have been reference to Rule 1 order or another order altogether. Where are we getting that from? And my lord, that is first part. Second part is, this is a case where there is attachment. Now, the office, let us say, does not issue the attachment warrant and issues only the attachment order to other side. Since the office did not issue attachment order, or the judge did not write in the order specifically to say attachment warrant is to be said, can it be interpreted to say that therefore it is not an order passed under Order 38 Rule 1 or Rule 3? It has to be construed as some order. But where is that power of passing some order coming from then? There is no such provision here to interpret it like that. And my lord knows, when a question comes as to the jurisdiction of court on an aspect, the presumption in law is in favor of having jurisdiction. Particularly prima facie, if I am able to show that. Therefore, my lord, this interpretation to say Order 38 Rule 5 contemplates of 2 stages. The court may have passed an order, but the court did not issue warrant to me. Since the court did not issue warrant to me in a particular form, that order that is to be passed by the court is not an order passed under Order 38, Rule 1 or Rule 3, Rule 5.1 or Rule 5.3. Therefore, you have to go before the court, and the court passed an order, Order 38, Rule 5 only. Rule 5 does not even talk about dismissal of the application or vacating the attachment order. Rule 6.2 specifically says attachment may be withdrawn or make such order. Application is dismissed. This is not. I am very sure it will fall under withdrawal of order, because withdrawal or dismissal of the application is nothing but withdrawal of the order. Even if it were to be strictly construed, is it not make such order as it may think fit, as it thinks fit, fall within the definition of dismissal of the application? Therefore, my lord, no, my lord may see whether the trial court has applied its mind to the order or not is evident from Annexure D.
Yes.
My lord, if my lord can go to page number, ink page number 160.
Yes.
Last para in page 160, my lord. Plaintiff is claiming a sum of rupees 8 crore 4,59,495 from defendant along with interest at 12% per annum. Along with the plaintiff has produced confirmation of amount executed by defendant on various dates by mentioning as balance confirmation accounts. In respect of IA2, plaintiff has produced encumbrance certificate and also copy of memorandum of title deeds and further sale deeds executed by defendant in respect of item 2 and 3 of the scheduled properties. These documents prima facie establish that defendant is selling his properties bit by bit. Mere confirmation of the balance by itself does not serve the purpose. In spite of selling 2 items of plain scheduled property, defendant has not made any payment towards confirmed balance amount. If defendant is allowed to sell his other items of the properties during the pendency of the suit, it is probable that the plaintiff cannot recover the amount due from defendant, and such decree becomes a paper decree for the plaintiff. That apart, execution of above documents from last 2 months establishes the conduct of the defendant. Hence, balance of convenience tilts in favor of the plaintiff. If charge is created in respect of remaining items of scheduled property till defendant appears before this court and offers security by way of guarantee or otherwise for suit claim amount, no hardship would be caused to the defendant. My lord, is not a conditional attachment evident in this? Because it is not mentioned in the operative portion, can someone say, no, this is not a conditional attachment? You come and furnish bank guarantee or the other security, this will be vacated, is the order. Therefore, the order says the charge is created respect of other items of plain schedule except properties already sold by defendant under 2 different sale deeds dated 30th December 2022 and 9/1/23 till next date. 1 second, my lord, I will take your lordships through the document that is mentioned here. My lord, the property was charged to Canara Bank. What they do is they take no objection from Canara Bank, sell the property, they don't pay entire amount to Canara Bank, my lord. From 30th of December 2022 till date, what is the sale? In the sale that is made, they have taken more than 7 crore rupees to their account directly, check payment. Even after the interim order was passed, a sum of 4 crore rupees is received by them. The sale deed evidences this. No, my lord, the case is like this. I may have taken money. In the court, I will not admit. In the NCLT, I will go and admit because it was before they entered appearance. They were not aware that I have filed a suit on 20th of February 24. They come before court. In the NCLT, having conceded.
What happens in the NCLT?
Only notice was issued to us, and we have entered appearance, my lord, which is when we figured out that they have admitted to this, madam. And they admit that the principal I have claimed is 5 crore 90 lakh, my lord. They admit a liability of 5 crore 3 lakh rupees in the petition before NCLT. And this was on 20th of February, 22nd of February 2024. Whereas they come before the trial courts and file objection and they contend that no, we paid it against LC for up to 2019. Yes, we are liable, but they are barred by limitation. My lord, if my lord can take that petition, if my lord can go to ink page number 15 of this petition.
Yes.
Ali, serial number 8. List of documents attached to this application in order to prove the existence of financial/operational debt and the amount in default. Now my lords can come to page number 60, next page. Second entry from list of creditors along with invoices, annexure and collectively. Now my lord can come to ink page number 35 of that compilation. Last page, my lord. Serial number 139. SGK is the plaintiff. Amount, my lord, 5 crore 80, I'm sorry, my lord, it says 5 crore 86 lakh. My claim is 5 crore 91 lakh to the and my lord, this is even before the filed return statement. And my lord can now come to first page of this document and see the date of filing. 22nd of February, ink page number 1, my lord. 22nd of February 2024. And next page, there is an affidavit, my lord, where and ink page number 3, if my lords come to again, because at one page they can say typographical error perhaps. Ink page number 3, synopsis, dates and divides, last entry, 22nd February 2024, this petition is filed. Now, my lord, this is one part. Second part, as I said, is they have executed 2 sale deeds. Those 2 sale deeds are also produced before this honorable court along with the writ petition. The other earlier sale deeds. The 2 sale deeds are already produced, my lord. If my lord can go to ink page number 85 of documents filed by me on along with the memo in this honorable court, my lord. Yes, my lord. This is sale deed dated 30th of December 2022. This is the property, my lord, which they claim is mortgage to Canara Bank. If my lord can come to ink page number 95.
Yes.
In the table, under the heading consideration, 2.2, the purchaser has paid sale consideration to the vendor after deduction of income tax at source in following manner. 1, rupees 59,65,000 paid to purchaser, paid by purchaser on what loan to the vendor. Vendors is, my lord, this defendant here. By way of check number so and so, amount is 59,65,000. Next serial number is 1 crore 50 lakh rupees. Now, my lord can see transfer from purchasers to vendor's bank account. Next, my lord, because a question comes whether it's payment to bank.
All are payment to the Canara Bank.
No, my lord, not. That's what I'm saying. Payment made to vendor. Serial number 1.
To vendor's bank account, Canara Bank, wide so and so.
That is serial number 2, my lord. Serial number 1, 59,65,000 to the vendor.
By way of check.
Yes, my lord. And my lord, all 5 sale deeds that are before this honorable court, payment is made like this. More than 5 crore rupees is. Now, my lord, next also, serial number 3 is payment to Canara Bank. So, in this sale deed, my lord, so a sum of rupees 60 lakh rupees, 59,65,000 is paid directly to the defendant. Now, my lord, next sale deed is at ink page 114.
No, that is actually besides the point. That is not the issue.
No, my lord, I'm not that. I'm only pointing out the conduct also plays a role. And my lord, 3 sale deeds after the interim order was passed, there also 4 crore rupees is taken by them directly, which they did not produce before trial court also. My lord, anyways, coming back to the point, my lord, as I just to sum up, my lord, a reading of Rule 3 as it existed in 1976 before Sub Rule 4 shows that it is not 2 stages. It is only 1 stage. The court can pass under Order 38 Rule 5(1), and in that may also pass in the order, direct attachment. Therefore, it is clear. Two, Order 38 Rule 5 does not contemplate two stages. My lord, procedure should not defeat substantial right.
It does not provide a second order being passed.
It is not there at all.
The second order, if any passed, is under.
Rule 6.
Your comment.
Yes, ma'am. That's all.
What else? Did you get the judgment? Get like the judgment, right? 22, 22 or 23. Report of judgment. On the.
And my lord, these judgments relied upon by my learned friend do not say that Rule 5 contemplates two stages, two orders. There's nothing like that. It is an interpretation that is sought to be made. I will not dispute that if, let us suppose, my lord, Order 38 Rule 5, instead of attachment before judgment, a simple show cause notice was issued to me. I could not have, was issued to other side, I could not have come and filed a commercial appeal before this honorable. Therefore, my lord, my submission is, this appeal is maintainable.
Yes.
And my lord, the problem is, I have some urgency in the matter. Of course, it is subject to what this honorable court holds on maintainability. If it is held to be maintainable, my lord, as I said, the problem is on the conduct, as I said, now I specifically in the affidavit filed in the court have said they are selling the property, two properties are sold, where in fact they have taken the money also substantially. Now, my lord, balance properties are sold.
This is why we are asking you what is the stage of proceedings before the NCLT.
No, my lord, notice was issued to me. I have entered appearance, sought time to file objections. And my lord, and there also conduct, I have produced the notice received by me from them as an annexure to writ petition, my lord. That notice says they have filed this in October 2023. I'm saying after filing a petition for voluntary liquidation of the company, they are selling the property. And my lord, in the written statement, their contention is, it was mortgage. If I had not sold the property, bank would have sold it under surface. But in one sale deed, they have themselves received the money, my lord. Personally. My lord, there are 3 sale deeds that were executed by them. First sale deed, my lord, starts at ink page 1, dated 16th of March 2013. Interim order was passed on 20th of February. 2023, I'm sorry. Somehow I'm going 10 years behind. I'm sorry. 23.
Yes.
If my lordships come to ink page number 9 there.
Yes.
There's a table again on consideration. They're following the same format. First is 55 lakh rupees paid by purchaser to the vendor. Paid UTR number so and so 55 lakh rupees. Second payment is 20 lakh, 55 plus 20, 75 lakh. Third payment of 2 crore 18 lakh is paid directly to bank. Fourth payment of 31 lakh is again paid to vendor. And TDS also for vendor. Between page 9 and 10, my lord, a sum of rupees 1 crore 10 lakh rupees almost approximately has been received by them. Now, next sale date becomes all the more interesting. They receive the entire money on their own account. My lord, that's at ink page number.
The sale deed says, the recital says that they've already paid the amount to the Canara bankers for the NOC.
Yes, my lord.
7.
Yes, my lord. Correct.
Canara Bank.
Correct, my lord.
Has
Correct.
paid sum of rupees 2 crore
Correct.
18 lakhs to the Canara Bank out of total sale consideration of 3 crore 38 lakhs.
Correct, my lord.
Hence,
Whereas in the written statement, in their contention is if I had not sold the property, banks would have sold it. My lord, I understand a situation where somebody sells property and entire money goes to bank. And my lord, in the sale deed at ink page, if my lords come to ink page number 52 of these documents that I have filed. Again here, my lord, 15 lakh in the table at ink page 51, 15, 22, 37, 30, and 20. All these amounts are paid directly to the vendor. And all this after NCLT filing, my lord. And if my lords can come to ink page number 29 again in another sale deed. My lord, wherever it is paid to bank, they have mentioned directly. If my lords can come to ink page number 29.
Yes.
Entire sum is paid only to the vendor, no payment to the bank also. That is 53 lakh plus 98 lakh plus 10 lakh plus 1 lakh, total 1 crore 64 lakh. And on 3rd March, my lord, email, notice summons was served on them through email by the trial court. And all this after they go before NCLT and file a synopsis and claim that it has to be liquidated because there are no means. No, my lord, therefore I am saying my problem is, if there are further transaction on the, after the interim order, this is done. Therefore, my lord, the charge is created on the property subject to me satisfying this honorable court that the order under order 38 rule on 4 is valid, notwithstanding the fact that rule 1 is not complied with by the trial court in stricto sensu. That argument I'll have to advance. Therefore, my lord, my submission is let the charge which was created by the trial court, let it continue from the day, because my lord, in the between, if there is no charge created and if there is any transaction that is happening, it may not inure my benefit.
Yes. Yes. We'll reserve it for orders,
Only on maintenance.
only on the business. So for orders on the business meeting, please get that.
Lord, there are judgments, my lord, where the court has entertained the repetition, not the appeal under order 43.
On the question of maintainability, we'll,
I don't want to place and burden my lord.
no,
Yes,
not the,
yes.
under petitions, that is a completely different question altogether. Whether it is appealable or not is a question here.
Yes.
Number 4, Shetty Vignesh Shura.
Next to appear on behalf of Lord Appellant. My lord, appellant before this honorable court is, my lord, a nationalized bank. My lord, appellant entered a lease agreement with the respondent on, my lord, 7/2/2019. My lord, the lease deed, my lord, I may my lord, permitted to produce before this honorable court along with a memo.
Yes.
I got the lease deed also. My lord, after entering the lease, my lord, lease deed entered between the, my lord, the bank, the swell, my lord, Andhra Bank, and my lord, the respondent, lessor, on, my lord, 7/2/2019. My lord, on 4/3/2020, the bank got, my lord, amalgamation, my lord, by way of, my lord, notification by the central government. My lord, the notification directions, my lord, I have to merge with, my lord, the near about big branch, wherein, my lord, Union Bank is, my lord, next to my, the earlier premises. Therefore, my lord, I have to, my lord,
Yes.
my lord, I'll just
Yes.
point out, my lord, lease deed, my lord, 2 components. My lord, before that, my lord, what had happened, my lord, I issued, my lord, in view of, my lord, amalgamation taken place between, my lord, Andhra Bank and, my lord, Union Bank. I issued a letter to, my lord, my lessor, said that, my lord, on letter, my lord, dated on, my lord, 10/8/2022, said that, my lord, but because of notification, my lord, I got merged with the Union Bank of India. Therefore, my lord, I am vacating. And, my lord, 3 months time I have given. Till such time, my lord, I have paid the rent, my lord, it is not in dispute. 3 months time, and the 3 months time also I am ready to pay the rent. Wherein, my lord, my letter said that I have a deposit with you, and the deposit may be adjusted and take the key. That is, my lord, I requested by way of my letter dated, my lord, 10/8/2022, it is not in dispute. My lord, I'll just point out, my lord, lease deed dated, my lord, 7th February 2019, my lord, 2 clause. The first, my lord, at, my lord, the very next page, my lord, the second page number, page hakidira? Page ಯಾವ್ದಿದು? Page 3, second page.
page 3, my lord, my lord, first para. Page 4, alva? Page 4, alva? Page 4. Page 4, my lord, I'm so sorry.
Yes.
That the duration of the lease shall be period of 12 years. That is 6 years certain commencing from 7/2/2019, the day which I entered the lease, with the option for renewal of extension of the lease for a further period of 3 + 3 years on the same terms and conditions detailed herein, with increase in rent of 15% after completion of every 3 years during the lease period, which options shall be exercised or shall be deemed to have been exercised in the matter hereinafter provided. My lord, then my lord, lease covenants and rent and other things, it's both parties, my lord, they are not, it is not in dispute. And my lord, I'll just read the clause, my lord, 2(7). That is set page number 6. Not 7, 8, my lord. That during the continuance of the tenancy, lessee will keep the premises in clean and sanitary condition and deliver the vacant position to the lessor at the expiration or sooner determination of the period of or extended period of the lease, and will permit the lessor or his agent and workman at convenient hours in the duty time or enter the premises, view and examine the conditions thereof, and in case of the defects, etc., to give a week's notice to the lessor in writing to repair the premises, unless in the opinion of the lessee, immediate repairs are necessary for the safety for the premises and prevent serious damages, the lessee being liberty to get the repairs done and deduct the such cost from the monthly rent. And my lord, last one para, my lord, I'll just read. In clause 4, my lord, just 4. Next one. Page number 9, my lord, para 4. The lessor and lessee hereby mutually covenant as follows. If the monthly rent is not paid within the 15 days, my lord, 15 days after the due date, if thereby any breach or non-observation of the lessee's covenants therein before the contained in shall lawful, the lessor to terminate the lessor after giving a minimum 15 days return notice and obtain the possession of the premises in accordance with the law. That if the lessor fails to pay the taxes dues to him and in respect of the demised premises in the lessee, maybe if the chooses to pay his taxes adjust to the same to the failing to the lesser. Para 3. That in the event of the lessee desiring to vacate the premises on the expiry of the period of lease stipulated above, the lessee shall give written notice thereof to the lessor during the subsistence of the lease. The lessee shall have right to extend the lease for a period of 6 years, 2 options of 3 years each. The lessee may return notice to their intention to extend the lease for such further period. In the event of the failure of the omission to give such notice to the lessor, the period of the lease shall be deemed to have been extended for a further period of 6 years on the terms of conditions contained in lease sanction, letter number so and so, and subsequent modification letters, if any, done time to time. Next para. The lease shall be for a period of 6 years certain, with an option to the lease to continue the lease thereof for a further period of 3 + 3 years. The lessee shall, however, have the liberty to vacate the premise at any time during the option period of lease by giving 3 months notice in writing.
Option period of lease.
Please, my lord, it's a fact, my lord. I'm not disputing. My lord, here, my lord, the 2 things. My lord, the amalgamation taken place, my lord, by the notification by the central government. It is not in my hand, and in fact, my lord, I have given, my lord, till 2022. I have paid lease rent up to date, and my lord, the period of 3 months which I indicate, my lord, issued a notice. For that period also, my lord, I said, my lord, I paid the loan. My lord, here, my lord, kindly see the entire lease deed. Nowhere, my lord, it is mentioned, my lord, lock-in period or that word is, my lord, not in the, my lord, the existence of the entire lease deed. Therefore, my respectful submission before this honorable court. The suit filed before the, my lord, I'll just point out the suit prayer also, my lord, for a moment, my lord, kindly come to page number 20, my lord, the order starts, my lord, page number 20, 20, 38, 20, 20. Page number 20. My lord, next page number 22, my lord, the suit filed for, my lord, 2 reasons. Judgment. The plaintiff has filed the commercial suit against the defendant number so and so, section so and so, civil procedure for seeking the relief of eviction and arrears of the rent in respect of the suit scheduled property with the cost. In respect of, my lord, eviction, my lord, in fact, the very first day, my lord, I said you take the key. In fact, my letter also says I personally, my lord, met the, my lord, lessor. My lord, he is not collected. In respect of, my lord, eviction, my lord, the first day when I approached the, my lord, I got a notice. And my lord, I handed over the key.
Yes. Execution file?
Filed, my lord. Execution number, my lord.
Admit issue
219 of
notice to the
2024.
What is the, no, decree, the,
20, what amendment? 20 lakh, 20 lakh 55,662. Page number 78. Will.
yes, admit issue notice to the respondent. There will be a stay of further proceedings in execution on condition that the appellant remits appellant deposits 50% of the decree amount before the court below, which shall be kept in fixed deposit with mandate for
Grateful.
automatic release. Within 4 weeks, bank.
Grateful.
5 urgent. 6. Ravindra Gajanan.
My lords, I appear for the, my lords, senior is on legs, my lords, I seek a pass over. Six, yes,
Pass over.
please. Obliged, my lords.
Ordinary hearing. 7.
Appear for
Nagaraj Dam.
appellant in this matter, my lord.
Additional documents along with the main appeal.
Yes,
Already order is there.
Yes, my lord. And now, on the last occasion, my lord, there was a direction for me to file a list of witnesses. On
Yes.
payment of a cost, my lord, I have deposited and I have filed the list of witnesses also. And the government, if they have any list of witnesses to be filed.
My lord, I
So the
pray for
filing of
2
the list
weeks,
of
my lord,
witnesses,
to
my
take
lord, that's it.
instructions and file the list of witnesses. My lord, there is a direction that the Honorable Registrar General has to record
It
the
has to be
evidence.
conducted.
May be called after 2 weeks, my lord. If I have any list of witnesses, I shall file it within the 2 weeks, my lord. It may be called in the last week of this month, my lord.
The learned government advocate seeks 2 weeks' time to file the list of witnesses. If any. List after 2 weeks.
My lord.
Please, my lord.
Number 8. V. Ramesh.
Yes.
Let's say the case, my lords, say order is passed by the land tribunal. Again is the third person, my lords, both the landlord and as well as the tenant are dead. My lords, only the tenant's legal representatives were bought on record. My lords, landlords, my lords, legal representatives were not bought on record. My lords, kindly refer to the, my lords, the page 52, my lords. My lords, Annexure A, page 50 is the order passed by the land tribunal on, my lord, 26/6/2002. My lords, the landlord had died on 4/12/99.
Yes.
My lords, the land tribunal records takes the, my lords, the evidence which was recorded by the land tribunal earlier occasion when the matter was remanded back to the tribunal and passes an order granting occupancy rights in favor of the tenant, my lords, legal representatives of the tenant. My lords, there is a categorical finding by the land tribunal that none of the parties are contested the proceedings before without option, my lords, we had passed the order. My lords, it was the duty of the, my lords, tenant to bring the legal representatives of the landlord on record, my lords.
When is the order passed? Date
My
of
lord,
the order?
my lords, on 26/6/2002. My lords, he died on page 52, my lords, death certificate.
Yes.
My lords, on 4/12/99.
Hmm.
Yes.
Yes. What is the pending? When is the date?
The granted occupancy.
What allowed the petition directly and this was after the remand inquiry was conducted.
Granted occupancy.
case of the petitioner is that Venkata Supparao is the father of the petitioner. He died on 4/1/1999. Improved order was passed on 26/6/2000.
My lord, this is the second round of litigation, my lord.
Yes.
In the first round of litigation, my lord, 5/6/1981 was the first order which was passed by the land tribunal, my lord. At that point of time, the petitioner's father did not challenge that order. It was challenged by another person by name K.M. Basappa, and it came to be remanded. In the second round, this order was passed. Hence, the learned single judge has passed an order that the petitioner's father never challenged the orders of the land tribunal at the first instance. At page number 23, my lord. And after the first grant, third-party rights have also been created, my lord.
Nothing is placed before me to establish that the father of the petitioner had any interest in the subject matter of this petition.
My lords, he being the landlord, my lords, he natural, my lords, he is an interested person. Because the occupancy rights is claimed by the respondents, my lords. Lords, once the order is set aside, lords, the question of once again the landlord challenging that order, my lords, would be redundant. Because, my lords, after the order of remand, my lords, notices were issued to all the parties. My lords, third-party rights could not have been created. When the third-party rights have been created, has not been discussed by the land tribunal. My lords, third-party rights, if the third-party rights have been created, my lords, once the land is vested with the government,
Notices.
my lords, notice is served. My lords, notice is served, other side is not.
They're not appearing.
They are not hearing.
Lord, he is represented through a council, my lord.
Yes, it appears.
Paparity, my lords.
Not one, several.
Yes, my
My
lords.
Not one, several are.
Respondent number 3 is represented by a council.
R1 and R2, R7, R11, R12. There's an order which says appeal shall stand dismissed for R12.
My lords, is a purchaser, my lords, who was purchased his property. My lords, during subsistence of section 15 years non-alienation period, my lords. Section 61 says that, my lords, until and unless, my lords, occupancy rights is granted, my lords, he cannot alienate for a period of 15 years.
When was the grant?
My lords, grant is, my lords, in this 2002, my lords, order of granting occupancy rights. My lords, nobody produces any document to substantiate when this the property has been sold.
What was the other petition which was clubbed along with this? There appeared to be two petitions. No, no, no.
My lords, no, my lords, I think, my lords, regarding payment of court fee, another additional court fee was paid, my lords. Hence, it was. Court fee has been paid. Only one petition, my lords.
No, earlier when there are
Yes,
more than one. Yes. Respondents required to be heard. We'll have it on
Yes,
another day.
Yes, my lords.
Is listed on a near date.
19th. 27.
27.
They have
28.
they've already entered appearance also.
20.
28 last year.
28.
Yes.
27 now.
27 now.
Okay. Much only.
9.
I appear for responding this, my lord. I am the contesting respondent. My lord,
Yes.
I have reported the death of appellant number 5
as early as 5/4/22 itself. Now they file a power of attorney said to have been executed in favor of the appellant number 5 and that they are prosecuting. Appellant number 7 is also dead. No LRs are brought on record. Appellant 5 died on 10/12/22. I reported the matter before this court on 5/4/23. And now they file a power of attorney in favor of appellant number 5, who is dead. And they want to prosecute through him.
But multiple applications are filed to bring legal errors on record. The memo my learned friend is speaking is not served on me. I'll just verify from the record when it is filed.
Yes.
And I'll,
5/4/83,
make a
I
submission.
reported. I can't file. I reported the death on
Regarding
5/4.
office note 1, Lord, I have served the copies and I'm filing the acknowledgements. I'll file
Yes,
it in the
I-
registry, my lord.
Yes, I have received the copy. That's why I'm telling you. The power of attorney is filed in favor of appellant number 5, who is dead.
I'll just verify because there are number of parties, whoever is dead and legal, how many legal errors are not on.
Appellant 7 is also dead.
Please clear the,
I'll clear that.
after a week,
1 week.
just after a week.
Lordship, I record my appellant 7 is also dead.
Learned senior counsel appearing for the respondent submits that appellant 5 as well as appellant 7 are no more, and that the legal representatives have not been brought on record. Learned counsel for the appellant seeks time to verify and get instructions in the matter. List after 10 days. My lord, IA copies are not served on the state, my lord.
Given, and I will give one more copy. This
Please, sir.
much.
Copy shall be served on the learned government advocate as well.
Submission. Number 20, that is compromised. Parties are absent.
Number?
20.
Oh, the council are also here?
Yes, all the clauses.
Take it, 20. Yes.
My lords,
Lordship,
this matter,
you refer the matter for
mediation,
Settled
we
it.
settled there. In that regard, my lords, 20 lakhs, we have deposited it in the execution court. 5 lakhs, we have deposited it before this honorable court. Today, we are handing over a sum of DD for rupees 9 lakhs, my lords. And the court fees
Whatever
that
court
we,
we paid on the appeal,
Have to be-
it has to be given to us. only.
to the respondents. That's all is our understanding. And with this, we are settling the matter in toto, please, my lords. My lords, before this court, I am handing over the DD for 9.
Yes. That is for an amount of,
9 lakhs, my lords.
Please, I will hand over, that will be noted, then I will take back.
please. Is submitted by the learned counsel appearing on either side. That's the disputes between the parties which have given rise to this commercial appeal have been settled in mediation between them. It is contended that the settlement entered into between the parties has been reduced to writing in the form of a memorandum of settlement. It is stated that the appellant has agreed to pay a sum of rupees 34 lakhs towards full and final settlement of all the claims of the respondent. It is submitted that an amount of rupees 20 lakhs has been deposited before the commercial court in execution, and a further amount of rupees 5 lakhs has been deposited before this court in this commercial appeal. It is submitted that a further amount of rupees 9 lakhs is a check for a further amount of rupees.
Demand draft.
Demand draft for a further amount of rupees 9 lakhs is being handed over today by the appellant to the respondent in court. Please take the details.
What
Take
we
the
paid
details.
on the appeal memo shall be given to the respondent.
It is further submitted that the court fee of rupees 1,96,998 paid by the appellant before this court shall also be paid to the respondent, and the commercial appeal
shall be withdrawn recording these matters. Full stop. The parties as well as the learned counsel are present
Right.
in court today. And they submit that the entire disputes have now been settled in terms of the settlement arrived in mediation. Full stop. It is submitted that the payment of amounts as well as the withdrawal of the same by the respondent is also agreed upon between them. Full stop. Payment of amount, it is further submitted that the appellant has no objection to the court fees being paid to the respondent in terms of the agreement reached between the parties. In the above view of the matter, the commercial appeal is ordered in terms of the agreement reached, in terms of the memorandum of settlement arrived at between the parties in mediation. The said memorandum of settlement shall form part of the judgment in the commercial appeal, which shall stand settled and withdrawn in terms of the same. The payments of the amounts which are deposited by the appellant, as well as the payment of the court fee, shall be in accordance with the agreement arrived at between the parties. The court fee shall be released in favor of the respondent in terms of.
By this, the appellant has satisfied the entire claims of the respondent.
It is, it is further agreed between the parties that the entire claims of the respondent have
Are
been settled by the appellant in terms of
duly on
the
this day.
agreement entered into.
But executing court will directly to release that amount.
The commercial court as well as the registry of this court shall release the amounts as agreed herein to the party,
Yes,
to the
yes.
respondent.
Stand obliged, much obliged.
They have to sign. Yes. This is 20. Send it to me along with the statute.
Then,
Yes. It is a sixth order. Yes.
Madam,
21, Sanjay, sorry,
14.
number 10, 10. Harish Bandariti,
Yes. 2020.
That single judge's order, my lord, is justified. That is all that I can say, my lord, as a respondent. He will have to make out a case for admission.
Rival claimant. Rival claimant's appeal.
Sorry?
Rival claimant's appeal in the land reforms matter. His application was dismissed.
Appellant is not here.
The previous matter, he was the respondent's counsel. He was absent in the previous matter also, the matter which got adjourned.
Possession.
There is one memo, my lord, where he has given up the claim.
Entire extent of 75 cents and so and so is the land which is granted in favor of the first applicant. What is the entire extent?
The
in that
entire
survey
extent
number?
itself is, my lord,
75,
78 cents.
78.
78 cents. Lord, it is granted to the respondents at the first instance. Lord, after it is granted, my lord, he makes an application for 45 cents. That is also granted. So since there is a double grant, my lord, the land tribunal gives an endorsement saying, since it is granted to us at the first instance, question of granting it to him again for a lesser extent will not arise at all. Then the matter came before this court, my lord. This court said you could not have considered the applications, my lord, individually. You had to consolidate both the applications and consider. That was considered. And in the second round, my lord, it has been held that, my lord, I am the tenant and I am entitled to grant of, my lord, 78 cents. Now that is challenged in the second round once again. But the learned single judge, my lord, confirms the land tribunal's finding. That is how this appeal is there. Before the land tribunal, my lord, he has given up, my lord, the appellant here, and I have just now passed, my lord. He has given up, my lord, his claim to this extent. I have produced the certified copy. The first, my lord, is the certified copy in Kannada. I have translated it. It's a certified copy. So therefore, my lord, nothing actually survives.
This is on
79, my lord.
26,579.
Yes, my lord. Therefore, my lord, in light of this, as well as, my lord, attendant circumstances which the land tribunal has, my lord, found, confirmed to the little single judge. Lord, nothing survives.
Yes. You have to hear the appellant though.
Yes, my lord, very well, my lord.
List on some other day.
This memo may be taken on record, my lord. I have already served it, my lord. Memo may be taken on record. Put it.
Yes. Yes.
Memo may be taken on record. Matter may be relisted for admission.
Yes. Take the memo on record and relist. Yes.
Yeah.
21st, 27th.
Yes, sir. 28.
Yes.
Grateful, my lord.
Can we continue after lunch?
No, this only appeal copy has to be served on.
We'll serve it, my lord.
Please serve it and let
My
it be.
lord, my lords, the matter, maybe 2-day adjournment we want, my lords. In this matter, senior legs in apex court, my lords, to
19th.
kindly.
19th.
Yes.
19th, on day after 19th. 21st to 22nd.
23rd.
From the other side?
My lord, serial number, sorry, man, serial number 12, my lord. Respondent is also there, man. My lord, kindly have it on 29th, my lord. We have also filed the appeal and they have also filed the appeal challenging. It may be admitted and posted on for final hearing if they are agreeing.
Can it be?
It can be 12. It can be admitted, my lord.
Along with the admit and list along with the connected case.
It is also there, man.
If it is admitted and for final hearing, you're aware that it will not happen. We can list it on some day.
29th,
Along
ma'am.
with the other case.
It is already
Srinagar-
there, my lord. It is already connected. It may be listed on 29th, man.
Yes.
Please. Ma. Twenty-ninth could be.
ಮಾಡ್ತಾರೆ ಅವರೇ ಮಾಡ್ಕೊಡ್ತಾರೆ ನಿಮ್ಗೆ
ಎಲ್ಲಿ ಇವಾಗ
ಹೈಕೋರ್ಟ್ ಅಲ್ಲಿ ಈಗ
ಇಲ್ಲ ಇಲ್ಲಿ
ಈಗ
ಇಲ್ಲ
next
ಹಲೋ
ಏನು ಮಾಡಿ
ಹಲೋ
ಶುರು ಆಗುತ್ತೆ. ಕೋರ್ಟ್ಗೆನಾ ಹಾ ಸರಿ ಸರ್ ಹಾ
ಅವ್ರು ಹೋದರೆ ಇದ್ದಾರೆ ಇವರು ಡ್ರೈವ್ ಕೊಡ್ಬೋದು
ಇಲ್ಲ ನಾನು ಹೈಕೋರ್ಟ್ ನಲ್ಲಿ ನಾನು ಆಟೋದಲ್ಲಿ ಬಂದೆ ಪಾರ್ಕಿಂಗ್ ಸಿಗಲ್ಲ ಇದೆಲ್ಲ ಕ್ಯಾಬ್ ಬುಕ್ ಮಾಡ್ತೀನಿ ಸರ್ ಡ್ರೈವ್ ನನ್ನ ಕ್ಯಾಬ್ ಸರ್
ಅದೇನ್ ನಡೀತದೆ ಅಲ್ಲಿ
ಇನ್ನೂ 9 ಇಲ್ಲ 2:30 ಡೆಸ್ ಸಪ್ರೇಟ್ ಆಗಿ ಸರಿ ಲೇಟ್ ಆಗುತ್ತೆ ಮತ್ತೆ ಅದು ಇನ್ನೂ
ನೀವು ನಿಮ್ದು ಡೀಟೇಲ್ ತರ್ಬೋದು ನಮ್ಗೆ ಅವರೆಲ್ಲ ಯಾರು ಚಂದ್ರ ರಾತ್ರಿ ಹೋಗ್ತಿರ್ತೀರಾ ಕಾಲ ಒಂದು ಫಂಕ್ಷನ್ ಕಾರ್ಯಕ್ರಮದ್ದು ವರೆಗೆ ಅದೇ ನೋಡ್ಬೇಕು ಯಾಕಂದ್ರೆ ಪ್ರಾಪರ್ಟಿ ಅಂತ ಇತ್ತು ನಿಮ್ಮ ಇದರಲ್ಲಿ ಈಗ ಇದು ಸಿಂಡಿಕೇಟ್ ಇದು ಮೆಂಟಲೆಸ್ ಆಗಿದೆ ಅಂತ ಹೇಳಿ ಅಷ್ಟೇ ಸರ್ ಏನು ಅವ್ರಿಗೆ ಇದೊಂದೇ ಟೈಟ್ಲ್ ಇಲ್ಲ ಅದೇ ಲೂಸ್ ಕೇಂದ್ರದಲ್ಲಿ ಬರ್ತಿದ್ದಾರೆ ನಮ್ಗೆ ರೋಡ್ ಇಲ್ಲ ರೋಡ್ ಹೋಗ್ಬಿಟ್ಟಿದೆ ಅಂತ ಆ ಟೈಟ್ಲ್ ಹೋದ್ಮೇಲೆ ಯಾಕೆ ಬರಕ್ ಮಾಡಕ್ ಆಗಲ್ಲ ಆರ್ಟಿಸಿಯಲ್ಲಿ ಏನು ಸೇರ್ಸಿ ಅವ್ರ ಹೆಸರು ಸಾರಿ ಅವ್ರ ಹೆಸರು ಬರ್ದಿದ್ದಾರೆ ಅಲ್ಲ ಅದನ್ನ ಯೂಸ್ ಮಾಡ್ಕೊಂಡು ಅವರು ರೋಡ್ ಬ್ಲಾಕ್ ಮಾಡಿದ್ದಾರೆ ಅದೇ ಸರ್ ಮೇಲೆ ಕೆಲವು ಫೈಲ್ ಇರ್ತಿದ್ದೇನಪ್ಪ ನಾನು ಕಡೆಗೆ ಫೋನ್ ಮಾಡಿ ಹೇಳ್ತೇನೆ ಬೇಕು ಅಂದ್ರೆ ಮೇಲೆ ತಗೊಂಡ್ ಬಾ ಬೇಕು ಅಂದ್ರೆ What is the operative portion of the CH order? ಫೈಲ್ ತಗೊಂಡಿದ್ದೀರಲ್ಲ? ಇದೆ ಸರ್. ಫೈಲ್ ತಗೊಂಡಿದ್ದೀರಲ್ಲ? ಇದೆ. What is the operative portion? ಅದೇ ಈಗ ಎಜುಕೇಶನ್ ನಾವೇನು ದೊಡ್ಡ ಅದೇ ಇದೆಯಲ್ಲ ಇಷ್ಟು ಪಟ್ಟಲ್ಲಿದ್ದ ಯುದ್ಧ ಮಾಡ್ತಾ ಅಲ್ಲ what is the operative portion? Operative portion, just not for note, they don't So they have to claim the whole 3 acres they can claim. And
Pronouncement of judgment, 2:30 PM, seal number 51, Anirudh.
Respondent.
Charge shall be created in respect of suit schedule property as shown in IA number 1 filed under order 38 rule 1 and 2 of the Code of Civil Procedure for the value of rupees 1.55 crore. The trial court is directed to send intimation to the concerned authority to create charge over the scheduled property for an amount of rupees 1.55 crore. Appeal accordingly stands disposed of.
$52, Pavan GN.
Hearing for all three, my lord.
If petition is allowed, the order of the tribunal in application number 667 of 2024 shall stand set aside. Application shall stand dismissed.
Orders, 2:30 PM, seal number 29, Ganapati Bhatt.
For the
This
appellant
case,
is my lord. On
I'm-
the last occasion, I was submitting that I have moved this matter. Only 5 minutes time may kindly be given because my learned friend will interfere and don't allow me to make submissions, my lord. In this case, on 25/2/2020, this honorable court permitted the appellant to engage the services of an advocate. Iram,
Rajamma, Raki
Iram.
Please. You are representing her.
Yes, madam.
Please ask her
Yes,
to be seated.
ಕೂತ್ಕೊಳ್ಳಿ.
ಕೂತ್ಕೊಳ್ಳಿ ಆ ಕಡೆ.
ಕೂತ್ಕೊಳ್ಳಿ.
ಹಿಂದೆ ಕೂತ್ಕೊಳ್ಳಿ.
ಕೂತ್ಕೊಳ್ಳಿ, ಆಮೇಲೆ ಹೇಳೋದು ಕೂತ್ಕೊಳ್ಳಿ.
Paso, we'll hear it.
Thirty, Nandish Patil.
Lords, kindly have it next week, my lords. I'll comply with office objection. Date may be fixed, my lord.
Week's time
Please.
to
A
hear
date may
the
be,
office objections.
a date may be fixed, my lord. A date may be fixed
19,
For hearing the office objection.
for response.
31, Murugeshwi Charity.
I'm for the
Office
respondent.
objections in all the IAs.
I'm for the respondent.
Yes, who has filed the IAs? IA 1 of
Appellant
23.
have filed the IAs. Appellant.
My senior held up in another court, my lord. Kindly pass on.
Pass out.
Office.
So many office objections, madam. Please see that they are complied with.
Please, I will complete 1 week.
Week's time granted to comply with the office objection. Staff rule.
32, MB Chandrasekhar Reddy.
For the appellants, price for weeks time to take steps.
Address R3, second time, week's time.
Much obliged.
33, VB Shivkumar.
Wait for the first respondent.
Copy.
Copy of IAS has not served on.
Office objections, in the IAs. There appear
IAS
to be
copies,
office
so they were-
objections in the IAs.
But may I make a small submission? The writ appeal is on the basis where a transformer is to be located. There is no man's land where BBMP has said, if the electricity board transfers that, I can be safe, because there are children in the house, they may be anytime. That's all what's the order I'm asking them.
That
In
what
which
IA
event,
copy?
the writ appeal.
IA copy.
I have given the copies. The location of that also is pointed out.
Please serve the copy so that he can get instructions on that.
Could it be tomorrow or day after?
Next week, may kindly.
A date be given because
That counsel for the.
house is
appellant
constructed also.
Submits that copies of all IAs will be served on the learned counsel for the respondent who seeks time to get instructions. This next week.
Yes.
34,
Monday,
Government Advocate,
Monday day.
19th.
For 2 weeks time. 2 weeks time, sought for.
35. 14% Mohan Chandra P.
My lord, matter is pending before Honorable Supreme Court of India. SLP is still pending.
SLP is. Yes, what is the matter about?
Matter regarding the appointment of information commissioner. So I challenge the appointment of commissioners because there is a gross violation of judgment of the Honorable Supreme Court by the government of Karnataka. The learned single judge dismissed the writ petition. I prepared an inter-court appeal. This Honorable Court has imposed a exemplar cost of ₹5 lakh. I have challenged both merit as well as cost imposed by this Honorable Court before Honorable Supreme Court of India. Matter is still sub judice. I am one of the aspirant to the said post.
An information. Yes. Time has now to be further extended.
Yes, ma'am.
Time has to be further extended.
No. Matter is still due to paucity of time. Matter could not be reached before Supreme Court of India.
Yes, this chapter. Yes.
36. Nagaya.
For the appellant in this case, Madam. Lordship, appellant number 1 also passed away, my lordship. I am filing in this.
Sorry.
Appellant number 1 also passed away, my lordship. I am filing application in respect of appellant number 1. In response, this is the respondent. I need time, 2 weeks time, my lords.
Yes, please file it in the registry.
Please, madam, 2 weeks time. Granted.
Yes,
Much obliged.
37.
it is submitted by the learned counsel.
37.
Please record it. Yes.
30.
It is the
38.
Respondent number 5. The question in this petition before the Honorable Single Judge was as to whether an industrial area, the liquor and establishment, that is hotel and boarding house, can be established. The learned single judge passed the order passed by the Deputy Commissioner of Excise, turning down the objection of the other side. The appellant herein had earlier approached this honorable court in a public interest writ petition. That has been dismissed. And still seeking leave to appeal, is approached against the order of the learned single judge.
There is
The establishment is working for the last 4 or 5 years. The definition of industrial infrastructure includes the hotel and boarding house and the refreshment room.
And keep this one.
One problem always in this area is whenever a new establishment comes, the other rival trader will set up people for hire or reward, who will come to the court.
No appearance for the appellant?
Sir, it is all
Dramaya.
just taken a chance and after 4 or 5 years now, the industry is working, the establishment is working and
No appearance for the appellant. Just after 3 or 4 weeks. We'll see.
$39. Arvind Basappa.
Your petitions comes in. There is an office objection raised, my lord, where, my lord, the learned single judge has deleted the name of the fourth respondent. Is not,
Third respondent, I'll pass on the order passed by the learned single judgment.
R3 in writ petition is not made party to this writ appeal.
I have also stated in my petition also, my lord, the name was directed to be deleted. I'll just pass on the order. At last page, you'll ask my kind gentlemen. There is no need to bring the LRs of the deceased respondent number 3, the respondent number 4 having acquired the insurance of the deceased. Petitioner makes a note besides the cause title of the above. This is a vendor's vendor. My vendor's vendor, they need not be brought on record. So thereby, my lord, I will ask my kindly officer judge may be overruled that. The other matter, I'll point out with the facts of the case.
Submitted by the learned counsel for the petition. That's the, for the appellant. Third respondent in the petition had passed away. And the learned single judge had held that there is no need to bring the legal representatives of the deceased third respondent on the party, since the fourth respondent had acquired the interest of the deceased. The above view of the matter, the
facts.
office objections stand overruled. Yes, listed for, can be listed. Can be listed to another day. There is nothing further. It has to be listed for admission now.
Yes, ma'am.
List for admission.
Obliged.
40.
Serial number 10, fourth time. What is serial number 10?
No, 40.
Item 40.
Yes, please.
Office objection at serial number 10 for the fourth time.
I have to return a letter to the government. I have to court fee.
Court fee.
Yes, please. I have to, 3 weeks may be added. Only court fee. 3 weeks
3
may be.
weeks time granted
Please.
to cure office objection number 10.
And then one more that I have to stay is an urgency for that not initiate the government.
Not before the
Yes,
court
please.
fees paid.
Yes, I'll pay. Much obliged.
Yes.
41.
I'm moving to this one. With an Hills and some other court. We need to, we'll comply with the office objections and we need to file the objections to the IA that has been filed by them. Any date after 26th, my lords.
We have not filed any IA. We have only filed for vacating stay.
Yes, vacating
IA is
stay.
filed by him. We have filed for vacating stay. The very jurisdiction of this court itself is not there, my lord. Your lordship has kept the office objection open and granted a stay of the entire proceeding. It is a simple suit of an eviction. More than 50 lakhs is due. He's party in person there. He's an advocate by profession and party in person is appearing. He's not paying even 1 rupee rent and he's torturing the unwantedly innocent people and he's filing litigation after litigation. It's a wrong forum which he has approached, your lordship. He has approached against Order 7, Rule 10, my lord. He could not have approached on
Any
a
office
commercial appeal.
objections?
Order 43, it's not attractive.
Moment, what was the office objection?
The relief has to be changed, my lords.
Jurisdiction
May
itself.
kindly recall. The relief that we sought for has to be changed. That is the only office objection. Yes, the relief, the prayer column.
Maintainability.
The prayer
itself.
column has to be changed. And they file an application, whatever the application that we need to file objections.
Based on maintainability as well.
Yes, my lords.
That has to be argued.
Yes, my lord.
It
Yes,
has
my
to be
lord.
ordered.
Any date after 26th, my lord.
No, my lord, this is
26th, like
dragging the
instructing
proceedings,
counsel
my lord.
as he's gone to Delhi.
No,
She
this
is coming
cannot
on
be-
26th, any day after 26th.
He has taken the benefit of stay, my lord. He cannot drag the proceedings, my lord.
I'm seeking only 26th and accommodation. I want to file my objections to the application that is filed by them. Any day after 26th, please, my
For
lord.
hearing on maintainability of the appeal.
Yes.
We list it on the 23rd.
20, any day, 27th, my lords.
27th.
Obliged. Interim order may be extended.
Till
Yes.
then.
42. Same.
42 6.
42 is the same, your lordship.
43.
27.
43, I appear for respondent number 1, my lords.
This is a matter, if I may just take a minute. This is a matter which was heard probably, what was stated was, that the appellant herein is he booked a flat with respondent number 4, which he proposed to build. And from respondent number 1, he had obtained a 3.58 crore loan, which was sanctioned. But 2.5 was disbursed and directly remitted to the respondent number 4 builder on some, this one that there is a slab which has been constructed. But he had not constructed any slab, and subsequently he had overshot all deadlines. Thereafterwards, the appellant had given 50 lakhs or 60 lakhs as advance also, which was part of it. At that juncture, it was stated by the appellant that I'm cancelling the flat now. Please refund back the amount whichever you have to the respondent number 1. And he portrayed, the respondent number 4 portrayed that yes, I have entered into an OTS with the respondent number 1 bank and refunded 2.5 crore rupees, obtained collaterals. Collaterals were released by respondent number 1. Though such being the case, now respondent number 1 bank is prosecuting the appellant for recovery of money for the entire loan amount. So hence I was asking for a stay. And furthermore, this honorable court in this situation, it is no longer a centigram, my lord. A judgment has come out holding that the flat owner should not be penalized because the disbursement has directly gone to the builders and they have to refund it. Flat owners need not be this one. I have already produced the judgments, please.
But there
On
appears
these
to-
grounds, I'm asking for a stay.
My lord, there appears to be a delay application, my lords. I'll file my objections to it. Appeal was preferred after 780 days, my lords. I'll just file my
Because
objection.
for the reason being, my lords, we were unaware. We were under the impression that we had asked the respondent number 4 builders to go forth and clear the amount. And a letter was written by respondent number 4 builder. Yes, the collaterals are now released. The loan has been satisfied. I have placed a memo, please, my lords. My lords may have page number 66 for a moment of the memo. On 3rd March 2021, this letter emanates from the appellant.
This one.
66, please, in page 66.
Yes.
A letter emanates from the appellant to the respondent number 4 builder stating that though I have paid about 50 lakhs, 60 lakhs, I am going to forego that 2.75 what has been disbursed to you from the respondent number 1 bank. Please go forth. If they are ready for an OTS for that amount, pay the amount, finish it off. And at page 67, he mails us a letter that this is a no objection which has been obtained from the respondent number 1 bank, whereby they have accepted 2.75 crores from the respondent number 4 builders, and they have released the collateral. He portrays to us that now the loan is finished. This is 67. It is stated that the bank has now closed the loan account. They have accepted the amount. They have released the collateral. Though such being the case, my lords, a judgment is now against me, asking for full recovery of the loan. They have my lords, shadowed this from the honorable trial court's notice.
Yes.
And furthermore, it starts at page, my lords, 100 and it starts at 168. It was a bunch of petitions which were filed in a similar situation. This honorable court held that the bank, respondent number 1 bank and alike banks cannot seek, the operative portion is 145, please, my lords. The reasoning, my lords may find at page 129. It starts at para 4, please, my lords. It states that there was a tripartite agreement, which is the same case here. On the basis of a tripartite agreement, which has a clause as if F, which states, clause F and I, in the event the borrower cancels his allotment or booking allocation of the said property, or in the event of PNB HFL, which was the respondent number bank, alike bank, my lords, cancelling his allotment so and so on the behalf of the borrower by virtue of the power of attorney executed by the borrower in its favor,
the developer undertakes to refund the entire amount as agreed in the agreement of sale and agreement of construction after deducting cancellation charge, etc. to so and so PSL after deducting all the outstanding amounts, refund the surplus if any to the borrower. Clause F is borrower specific, whereas clause I or L includes both borrower and PNF who are the agent of borrower may cancel the booking. Further, this clause imposes an obligation upon the developer to refund the amount received from the borrower in the event of cancellation. The vehement contention of the learned senior advocate, Mr. So-and-so, appearing for respondent that under clause AB in the tripartite agreement, both borrower and developer are jointly and severally liable and repay the loan is bit difficult to countenance. The said clauses are so and so. It has been stated that it is not jointly and severally that the person who has taken the loan, that is allottee, as well as the developer are liable.
Your agreement also has the very same.
Please, same, please.
Developer
Same.
itself is not on record, my lords.
Developer was not on record before the honorable trial court. He has not come on record here also.
Yes.
And it is the same clause, my lords, and it has been held. The my lords may kindly have page 145 for a moment. It is the operative portion. A mandamus was issued restraining the respondent PNB Housing Finance Limited from taking any coercive measure against the petitioner for recovery of any amount comprised in the loan agreement and tripartite agreement in question. CIBIL was directed to be restored if there is any loss to the CIBIL score of the person. Basically, it was held that the allottee is not to be made responsible because I will purchase the property, please, my lords. I will pay some 50 lakhs, some amount, meager amount will be paid as an advance. Remainder, I will take loan. And the loan will not be disbursed to me, but it will be directly disbursed to the builder. On my lords, his informations, he has to communicate saying that I have come up to so and so slab. I have come up to so and so slab. That slab wise, it should be given. But in this case, he has taken a one-time amount of 2.75 crores on the basis or on the representation that I have come to such and such a slab. But whereas he has not come, that has not been verified by the bank. And now I have been penalized.
I'll file objections to the delay application as well as the main petition, my lords.
Please do. Turn the counsel for the respondent seeks time to place objections on record to the delay application. Over. What is the stage?
Until that stay, please, my lord, it's on 17th. Previously, it was there and I was directed to serve them. I have served them by hand. And it was posted on 5th, but it was an inconvenience. It was not posted. That's why stay may be granted.
Just after 3 weeks. In the meanwhile, further proceedings in execution shall be kept in abeyance till the next.
Obliged, please.
Forty-four, Mahesh.
My lord, appear for the appellant. The appellant and first respondent are sisters. They got two properties, side-by-side properties from their father. The appellant is in the United States. The respondent, first respondent, is in Canada. Then the appellant decided that I'm close to 70 years old. Let me build a house in one corner of the property allotted to her. She built a house. Sister then said, no, I want to start a club. Why not we join hands and do all this? It was all agreed. Coco Club was started. Then what happens? Sister takes a power of attorney from me and said, listen, we'll do all this conversion, etc. What she does is 1/2 undivided share of her property, she transfers to me. 1/2 undivided share of my property, she transfers to herself. Now it's a complete mess. Now what's happening is she's walking. She says, this tree, 50% is mine. If I take the root of this tree, you take the root of that tree. This is going on. Only one submission, my lord. I have built the house in this country, my lord, subject to correction. There can be dual ownership of property. Somebody can own the land, somebody can open the building. Please go to the gift deed, page number 142, is what she has given me. Everywhere the gift deed is only of land.
If I remember correctly.
Yes.
This matter we had.
I know. Your lordship has granted some. My only request is.
We are only asking you one simple question.
Yes.
It is the property belong to the father.
Yes.
it has been, the father had actually,
Divided it by will.
yes, the will, if it had been respected, probably this would not have arisen. Anyway, between siblings.
Yes.
Is it not possible to try an amicable settlement of this issue?
We are ready, madam.
If
Both of them are fairly elderly. One is sitting in the United States, one is in Canada. No. One is here now.
One is here only.
First respondent is here.
the mediation we can attempt even through, if one person can.
We
be
will come
here.
through video conference. We'll ask her to come through
Exact-
video call. Yes,
Exact,
we would do
it's
that.
possible because
Yes,
here is a case where the property ultimately, it
ultimately.
now has to go back to what the father initially.
Yes, I think ultimately I was looking at it. The solution seems to be
What the father wanted.
pre-gift deed. It has to go back there. Otherwise, nothing is going to
It
happen.
would be the
Yes,
ideal situation.
yes,
I remember when this first came up, we had expressed
yes.
our mind in as much as what the father had thought. The separation was probably what was best for both of you.
Both for them.
And if that had been honored, if that
Not-
will, the intention of the donor had been honored.
All this
this
wouldn't have
would
happened.
not
Yes, madam, I agree completely.
Anyway, now that they're all said and done siblings.
Yes, siblings. Yes,
Instead of the court trying
yes,
to bring about a resolution, is it not better that they try it among
yes, madam.
themselves?
Yes, madam.
I'm sure that if.
I'm
given
fully in
half a
agreement with what your lordship says.
Given half a chance, if you can, just because the party is, at least one of the parties is here. If you can, at least some kind of a forgiveness in at least part of what is.
We can give
happened.
it a try, my lord. There's no issue at all.
I have checked with my client, absolutely no problem for the mediation. But before that, my lords, one submission. On the last date of hearing, learned counsel appearing for the appellant had provided an undertaking, saying that they will not obstruct me from entering into the property and house. I would like to just show, my lords, what has happened is,
Please leave it there.
my lords, there is,
Start the mediation process.
no, we'll start, my lords,
And
one
in the
submission.
mediation process, all this can be worked out.
My lords,
Yes.
overnight,
Instead of orders on orders in.
I
in
don't need an
these,
order, my lords. I want to bring it to my lord's notice. Overnight, the entire house has been fabricated. Okay, I'll show the photos. Earlier, there was no.
This is exactly the
fabrication.
point,
And
but they called the police. They
Overnight,
manhandled.
my lords, may I submit?
That
my
is
lords?
why
When
when,
my
that is why when
senior-
your lordship
senior
said
advocate was
mediation,
submitting,
I
was not
kept quiet.
I'll
It is
just
only
submit.
to avoid this that we.
Yes,
My lord, she has no house to stay. That is the problem. Here in the application.
my
they
house?
admit- No, I will show you. They have admitted in the application before the trial court that I was residing in that house. That is, which is part of the pleading before my lords. Now, my lords, they obtain an order, ex parte order from my lord saying that I should not come and demolish anything. To overcome that, what they do is to take advantage of it. They barricade the house. I will just show the photograph, my lords, earlier. If I can just pass the photograph, my lords will only understand the intent.
After which an order was.
Yes, well, after that they have done it.
Thereafter.
After that they have done it.
My
That is
lord-
my submission.
my lord, I have been manhandled. I've got video.
My lords,
That's why I did not open my mouth.
fabricated. They say, now you go open it, I will see how you will open
lord,
it.
that
If
is
you
why-
open, you are destroying.
My lord, that is why I did not say anything because your lordship suggested mediation. I didn't want to get into you,
My lord,
me and all
Doesn't
that.
have a house. She doesn't have a house to stay.
She has a house in Morning
Stays-
Glass Road.
No, no,
stays
that's not her
elsewhere.
house. Let them file an affidavit that it is my house. My lords.
We have already filed
It
an
is not her
affidavit.
house.
It is to avoid this.
My lord, she is willing to mediate. She needs
Yes.
a house to stay. I will take my lords through paragraph number 30, my lords, of their own document where they
My
admit.
lord, have mediation tomorrow, my lord. I will ask her to get,
Till then, why can't they give access to the property?
I
my
won't give
lords?
access to my house till now. Let the
It's
mediation
not their
happen.
house, my
Then we'll-
lords. With due respect, not their house.
My lord,
lords,
10 crores
she
I
thinks
spent,
they-
build a house.
We have absolutely no difficulty here in this on the merit.
My lords, I
Only
understand, my lords,
because
she
you-
doesn't have a
your
house to
siblings
stay.
and.
I agree
because
with your
there's a
lordship.
chance we thought of settlement of the issue, that we thought we would not go into the facts because every order only makes things worse.
No, I
Lordship will
very
fix
well
a
understand, my
mediation
lords.
tomorrow.
Eh,
I will ask her to 3 o'clock tomorrow, not 3, maybe day after tomorrow morning because it will be 12 hours behind. So it becomes a little. Anytime, I'll ask her to keep awake.
My client will be available any day, anytime, my lords. That's no problem.
Tomorrow.
Tomorrow,
Very well.
tomorrow by about
Can it
10:30,
be referred to some
10 o'clock in
expert
the me-
mediator, my lords?
10 o'clock in the morning because where is she staying?
10 o'clock will be the middle of the night for you. 3 o'clock in the afternoon.
3 o'clock.
Third, the learned counsel appearing on either side. In view of the fact that the petitioner and the The appellant and the respondent are siblings.
Anyway,
They are of the opinion that there must be an attempt to settle the disputes between them amicably by way of mediation. The parties are also agreeable for the same. In the above view of the matter, then the parties shall appear before the respondent is available.
respondent number 1 is here, my lords.
The first respondent shall be present before the mediation center,
Bangalore Mediation.
Karnataka Mediation Center.
At Bangalore, Karnataka at Bangalore.
Karnataka.
Yes, yes,
at
yes.
Bangalore. Tomorrow at 3 p.m. Date please. At 3 p.m. And the appellant shall join the mediation online.
Expert mediator.
So can we do that?
Can we go to this mediation, can it happen in the conciliation center?
Yes.
You want it at the conciliation
Yes.
center.
It will be better. I'm a retired High Court judge.
Is the video
Then what
conferencing
happens is
some
senior, maybe a retired judge of this court could be the mediator and sort this.
And will be the.
Parties will bear the expenses. my
Yes.
lords. Whatever expenses, parties, maybe.
It's all that.
Can you suggest a mediator then? If you can,
My lord, known so many people to suggest anybody's name, I'll leave it to your
No, no,
lordship.
I have no objection. Any name
Lordship may-
suggested by senior advocate, I have no.
That's a good idea. Who's close?
My lord, if I may make a mention, his lordship Justice N. Kumar had also attended a mediation in California. And then he was closely associated with, maybe he would be the best expert mediator.
if he is free, that is.
We can ask him.
We can ask him.
We'll ask him.
The parties have also suggested the name of Justice N. Kumar, the judge of this court, as a mediator, subject, of
He's
course,
available.
to his availability and convenience.
My lord, we will be able to inform the court officer by in about an hour's time after we speak to him.
Speak with.
We'll speak to him and get
Therefore,
back.
not at the Karnataka Mediation Center, it shall be at the conciliation center.
Conciliation.
Yes,
Nijaba.
Anija Bhavan.
3 p.m. tomorrow.
Yes.
Will you please inquire about the convenience and then
That's what I will.
the time as well as whether he
I will-
convenient.
Grateful.
Grateful.
Interim order may continue since.
Interim order is already granted.
And the undertaking.
Remain in force
Grateful.
till the next date of hearing.
Yes.
We'll list this after, should you, or list along with the report of the.
Yes.
of
Right.
the-
I'm aware.
That's what happens in the. How many other? How many? Okay. Okay. Okay.
Continuation, see number 13, Sampatye.
There is a matter arising out of the common order of the learned single judge. The batch of petitions were considered more than 200 matters pertaining to Arkavati layout. Similar appeals, my lord, which had come before this honorable court, confirm the order of the learned single judge. My only request, my lord, is that certain portion needs to be clarified, my lord, which has not been done in the earlier. Lord, the petitioners, my lord, measure owns a land, my lord, all that, my lord, I will not argue on matter of the adjudicate whether the right or wrong. Not the issue of lands to be dropped or not, my lord, now being relegated by forming a committee, my lord, the Honorable Sri Justice K.N. Keshanarayan committee. My lord, page number 184, my lord, the order portion, which, my lord, I'm only aggrieved.
Yes.
My lord, after the committee orders, my lord, the BDA is given 180, sorry, my lord, 180.
180.
Please, my lord.
Yes.
Please, my lord, the small a, my lord, the parish says, my lord, the committee has to examine all such representation received by the BDA pursuant to Division Bench order and Bandurama Swami's judgment. placed before the committee and submit a report to the BDA as to whether such claim or claims would fall within the exception carved out under a judgment for deleting the lands or not. The BDA shall thereafter take steps to delete or include such lands. Now, my lord, what this is, my lord, is the second round of litigation. Earlier, my lord, the landlords came up before the honorable single judge. The entire accusation notification was quashed. My lord, that was taken in appeal before this honorable court. This honorable court, my lord, noticed there a discrimination notifying the land. But my lord gave a certain guidelines of 6 guidelines, my lord. That guidelines, my lord, also find at page number 180, 124, my lord.
That is Bondu Ramaswamy.
Please, my lord. 124 is the guidelines of the honorable division bench, my lord, the earlier, 124. My lord, there are 2 persons, my lord, the site owners and the landowners. I am the landowner, my lord. My taken relief in respect to mine, my lord, the landowners at page number 126 at the bottom, my lord. Capital D. Insofar as the landowners, excluding the site owners, are entitled to the following reliefs. All the petitioners who are landowners who are seeking dropping of the accusation proceeding insofar as the respective lands are concerned, on the ground that their lands are situated within the greenbelt area, they are totally built up. Properties wherein they are buildings constructed by charitable, educational and or religious institution, nursery lands who have set up factories, their lands are similar to the lands which are adjoining their lands but not notified for the accusation at all, are all permitted to make appropriate application to the authorities seeking such exclusion and exemption and producing documents to substantiate their contention within 1 month from the date of this order. It is made clear that the BDA shall consider such request keeping in mind the status of the land as on the date of preliminary notification and to exclude any development, improvement, construction put up subsequent to the preliminary notification and then decide whether their case are similar to that of the landowners whose lands are notified for accusation, notified and whose objections were upheld and no final notification issued. In the event BDA come to a conclusion that the lands of those persons are similarly placed, then to exclude those lands from the accusation. My lord, these 6 guidelines, as my lord, they've noted. My lands, my lord, my ground, my lord, the guidelines is from along the adjacent lands has been dropped out. Now, my lord, the BDA also, my lord, and considering, my lord, this also went to the Honorable Appeals Court, my lord, it was confirmed with the further clarification. All that, my lord, landowners are required to do is make a representation, substantiate that how my lands should be dropped. Considering this, my lord, an endorsement was issued by the BDA, saying, my lord, by considering the division bench order and the Honorable Apex Court, an endorsement issued, my lord, at page number 249. It's a translation or something, the original at 248. Well, the 249, my lord, the reference lordship may kindly note.
Yes.
Issuance of no objection certificate with respect to the land so and so. And my lord, the reference is order of the Honorable Division Bench in writ appeal 262, it's the main order. And all the order and also my representation at serial number 6, my lord. Considering this, my lord, the para says, in connection with the above subject in reference in terms of the order dated so and so passed by the Honorable High Court of Karnataka in writ appeal so and so, wherein stipulation guidelines have been formulated for excluding the lands subject to accusation for the formation of Arkavati layout from the purview of land acquisition proceeding, which has been upheld by the Honorable Appeals Court in the case so and so, passed by the Honorable High Court in the writ petition so and wherein stipulations have been contained with respect to the action to be taken in cases requiring re-examination in terms of the order passed by the government in its notification number so and so. They note the nominated land acquisition officer have conducted review and re-examination and in terms of the order passed for excluding the lands outside the purview of the land acquisition proceedings and also considering the opinion of the Honorable Advocate General, which has been placed before the authorities meeting and in the background of decision taken to act accordingly, lands in survey number 59/5 and 59/6 belonging to BK Shankar so and so situated has been excluded from the land acquisition proceeding. Lord, this is noted in my lord 13/11/2013. My lord, yours of giving this endorsement, no, still, my lord, in the subsequent notification in their 2014 has been notified. That's the case of the petitioner, my lord, that despite, my lord, they though themselves have an endorsement resolved. And also, my lord, what is important is, my lord, they took opinion of the learned advocate gentleman. After all this, my lord, they decided to exclude. Yet, my lord, it's again in the second notification based on the exercise of the exercise to delete, my lords, considering represent. Yet again, my land has been notified. No, my lord, after all this, my lord, I accepted the Honorable Single Judge order that to go for the committee, my lord. I already represented before the committee. My only apprehension is that, my lord, the Honorable Committee, my lord, hears both the landowner and also as well as the BDA. My lord, BDA opposes, my lord, saying that this land has been required for the acquisition process. My lord, both BDA's contention and the landowner's contention will be taken into consideration. A final order will be passed by the committee saying that, my lord, the land has to be dropped or not, keeping in the mind that, my lord, the guidelines of this honorable court and the honorable apex court. Now, my lord, the what portion which I read at page number 180, it says, my lord, the committee has to examine all the cases and has to submit a report to the BDA. Then BDA has to take a decision whether that report is right or not. My lord, whether BDA should not be given such a power to say right or not, because BDA is opposes before the committee. My lord, BDA's throughout stand is that I want this land. My lord, the honorable committee, my lord, decides keeping in mind the decision of the honorable apex court and this honorable court. My land comes under this guideline. My lord, there ends the matter. And the BDA has to straight away act upon it. My lord, if they are agreed, then BDA has to challenge before this honorable court. Now, my lord, in the cases, my lord, I have come across with, the BDA will not challenge, my lord. The one case, my lord, which another matter, landowners, my lord, recommendation has been made by the committee saying that my land has to be dropped out from the acquisition proceedings. That has not been acted upon by the BDA. My lord, the mandamus was issued for that consideration. Despite mandamus, my lord, they did not do anything. I gone with the contempt. In the contempt proceedings, my lord, just I don't know, my lord, whether they're taken with the application of mind or not. They gave an endorsement saying that we want this land. That means, my lord, certainly rejecting the recommendations of the honorable committee.
They cannot, counsel.
Please, my lord, but they take the, that's, my lord, they take the privilege of,
Direction is specifically this.
please, my lord.
Examine all such representations received by the BDA pursuant to division bench order and submit a report to the BDA as to whether such claims would fall within the exemptions carved out under the judgments for deleting the lands or not. The BDA shall thereafter take steps to delete or include.
Delete or include, my lord, they are taking this as, my lord, they got a power.
Take steps to delete or include such lands from the acquisition on the basis of the report given by the committee.
Please, my lord, what they do is, my
If
lord,
they vary, if they depart from the recommendations of the committee, that's contempt.
please, my lord, that only on that clarification, my lord, I only want that clarification.
That clarification, my lord, what is an apprehension expressed by my learned friend?
Has the report
Has
been
it-
submitted as of now?
No, Lord,
No,
he has
Mr.
not gone before, he has not produced his documents before the committee.
I'm
He
sorry.
must
Lord,
consider
what-
at the relevant time.
Lord, why?
Because the judgment specifically says that it is for the committee, all the representations are to be forwarded to the committee. The committee constituted hereinbefore shall implement the order passed in writ appeal 2624. Therefore, whatever is stated in the operative portion, the guidelines in 2624, they will have to be followed by the committee. The
Please, ma'am.
report has to be then prepared
Please.
and then forwarded with submit a report as to whether such claims would fall within exemption.
Please, ma'am.
Once they submit a report saying that this claim falls within the exemption, there is no power in the BDA to.
But BDA, my lord, in one of the matter, I have this matter, my lord, if such
then
clarification is done, my lord, I'm only satisfied with such clarification. My lord, the BDA, what does?
No.
They sit as an appeal, my lord, as they decide and they recommend.
It is not for the BDA now to adjudicate.
Please, if the such clarification is,
Left to the committee.
please,
Once the committee adjudicates and submits a report, they have to accept it.
please, my lord, only,
He shall examine the claim on case-to-case basis and on being satisfied either that such claim being genuine or being contrary to factual scenario, shall prepare a report village-wise and forward the same to the BDA to enable the said authority to either delete such lands from acquisition or conclude them.
please. So one example, my lord, is one of the matter. BDA adjudicated and said, recommendation is wrong, we want this land. That cannot be done, my lord, only that is the apprehension. If they say, my lord, if lordship says, the BDA has to
What
only
are-
act upon.
What are we considering? We are considering one acquisition
Please, ma'am.
and whether that acquisition has to be proceeded with or dropped.
Please,
That does not stop them from acquiring further lands.
please, my lord.
If they require it for the purpose and if they can, as a matter of fact, acquire further land, that this will not stand in the way. We are only considering what, with
Please.
that notification, whether it lapses or not is a question we are considering in this writ appeal. How can a further notification of the same land, how can it be
Please, my lord, but,
This was a-
completely injuncted?
but my lord, may
This
just
was the second
clarify.
round of challenge to the very same notification, which was confirmed by the Honorable Supreme Court of India. And in the second round of the litigation, the petitioner wants to take an order which is not there in the order passed by the learned single judge. They'll have to confirm it to the correctness of the order passed by the learned single judge. Here, my lord, he is giving examples. If I am aggrieved by any of the recommendations, my lord, it is open for the BDA to take further action. if my petitioner has agreed by any of the so-called order to be passed, but now what has been now the order that what the petitioner is anticipating or is requesting this honorable court to pass is, not is trying to put up pressure tactics on the committee, not which may not be, in my respectful submission, may not be the scope of the present litigation here. But what has been happening, this order of the learned single judge has been confirmed by the division bench of this honorable court in two of the other matters. Several appeals were filed, my lord. This honorable court has confirmed the appeal, confirmed the order of the learned single judge, and my lord, now so almost 45–50% of the work of the committee is over. Now, my lord, at this juncture, my lord, my respect and the apprehension of the petitioner that I may not delete, exceed to deletion of the land where is, my lord, may go contrary to the finding of the learned single judge, wherein, my lord, 940 acres of a land which ought not to have been deleted has been deleted. Ought not to have been deleted, has been deleted. That's why a retired judge of this honorable court, not left to the committee of a bureaucrat. It's a retired judge of this court has been, and it's now coming here and saying that BDA will oppose deletion of a land, may not be apprehension at all, Lord.
That's my
But
only. My lord,
Yes.
please, my only request is, my lord, I just got some 2 documents. Lordship may kindly peruse it, please.
Is this true that this very same judgment has been taken in appeal and has been?
Yes.
No,
continued?
we are not went to the honorable apex court, my
You
lord.
did not.
Please, my lord.
You did not.
Please.
The same judgment has been upheld to the.
Please, my
apex.
upheld, my lord. I'm also initially, my lord, I said my only request was that, my lord, that only portion, because I only, my lord, even I have not argued that, my lord, the entire acquisition needs to be done. My only request is, my lord, I will go before the committee. I will convince the honorable committee. I have no objection to go before the committee itself. I already before the committee. My only request is that, my lord, after the honorable committee gives an recommendations or a report, my lord, the after that what happens after that, my lord, is only apprehension. For that, my lord, just me place 2 documents on record, my lord. Just.
Yes.
I should, but there's no pleading to that. No pleading to that effect. And what has to say why the order of the learned single judge is adding law is.
My lord, see, initially I also admit, my lord, there was no pleading, but after, my lord, going before the honorable committee, we faced this problem, my lord. That's the one. My lord, lordship may kindly, my lord, the page number.
He's arguing a PIL, I see.
No, my lord.
I'm sorry. But
Lord-
he is still gone before the learned committee. Committee has not yet taken up his case.
Lord,
He's
this.
not here.
Cannot act on speculations.
No, my lord. No, my lord. The what the BDA is done, also report, my lord. Page number 3 is the report of the honorable committee. Page number 2, my lord, is the Page number 2 is the
Pursuant to this judgment.
no pursuant to this testament, my lord. The first case before the honorable committee.
Hmm.
This was the first matter, my lord, dealt by the honorable committee, and after taking detailed, my lord, contention. Page number 2, my lord, the landowner, my lord, the sum of the writ petitioner.
Hmm.
My lord, he is Mr. S. Satyan and the BDA. My lord, the both of us contention will be considered, and the BDA, my lord, will be also be heard, and final recommendation, my lord, report will be passed, my lord, by the honorable committee. Page number 34 is the operative portion, man.
Hmm.
It's a recommendation, man.
34.
Please, page number 34 is the final.
Perfect. Oh,
Well,
yes.
sorry, mal, there is an
Yes.
in-page problem. Sorry.
Yes.
Page number 34.
Hmm.
This is the final, my lord, the report or recommendation will be treated as a recommendation. The honorable committee says, as looking after all the guidelines, well, this is the recommendation. In this case, my lord, the recommendation was to, my lord, to delete the land. The objector saying that they need certain land for road. No, that, my lord, accept road, you take for the drop the other lands, my lord, was the recommendation. Well, this has not been acted upon. Now, my lord, the mandamus was taken at the hands of this honorable court, page number 36. No, this also not been done, my lord, and the contempt was initiated at page number 440.
Yes.
No, my lord, in the contempt. No, my lord, page number 43, my lord, is the recommendation was taken into consideration by the board of the BDA. Translated copy, lordship find at page number 48.
Yes.
My lord, in these recommendations, my lord, they say, we want this land, my lord, instead of say, my lord, saying that we will go with the recommendation. If the recommendation are against them, they have to appeal before this honorable court. My lord, in the case of the landowners, if the recommendations are against the landowners will come before this honorable court saying the recommendations of the honorable committee was wrong. My land needs to be drawn. But in the case of BDA will not come before this honorable court saying the recommendations are against them. My lord, they don't do anything. When the person whose land recommendation in his favor, he runs behind the BDA and take the mandamus and contempt. And just to, my lord, maybe, my lord, just to overcome the contempt, my lord, such an endorsement. No, my lord, this person was again been made to again challenge this endorsement before this honorable in the writ petition. No, my lord, the recommendation is purely, my lord, to keep.
This contention is not correct. The above decision provided opportunity to the authority to verify the report of the committee and to take a decision whether to delete the land. That is not correct. That appears page 52, paragraph 2.
Of all this apprehension, my lord, because since petitioner, my lord, the landowners for 20 years, my lord, 2003 is the notification. Even after 20 years, my lord, he unable to enjoy the land. There has to be quite a smaller only, that's the only.
Lordship, may kindly see the order of the learned single judge at para 91, the direction. There has to be a village-wise recommendation. That village-wise recommendation, once the entire village-wise recommendation comes, my lord, either then we may even challenge or we may even leave it up to that. Not at this point of a time to asking us to accept only one report of a one particular survey number, not will not be in a position to say everything because not what is the land development of the area. Not I cannot go on choosing one particular survey number or the second survey number.
But then this stand you have taken in the second paragraph at page 52 does not appear to be correct. Because it appears to be your, is it the BDA stand?
Please, my lord, they have filed this in contempt petition.
That will be considered in the contempt. That issue, if that happens, then probably you will have to take it up in the contempt.
No,
It will
my
have
lord,
to be
but
considered.
contempt, my lord, what?
We
Please,
cannot consider the contentions of the parties in the contempt,
please, my lord.
which is not
But
before us.
they take shelter, my lord, why, if they ask us, why, if they pointed why do you pass this order, they take shelter of the portion which I pointed at, my lord, page number 180, because they say
So
to delete.
therefore, it is up to the court hearing the contempt of court case, either to accept this position or not.
My lord, the contempt, my lord, the
Yes,
contempt is
it's
followed the
accepted.
writ.
That is pending.
Contention is accepted. It is for the state government which issues a notification under section 48(1) and not the BDA. BDA is the beneficiary of the acquisition. State which runs the acquisition.
For the
policy.
BDA also cannot decide whether the notification after the committee has entered into this exercise.
It
The
is only,
BDA cannot also decide whether that is correct or not.
it is only the state government which has to do it.
The state government also now cannot, because the purpose of the committee
Yes.
is to decide whether the acquisition survives or not.
Yes.
Therefore, once the committee which has been appointed by this court on the basis of the guidelines provided by the Supreme Court as affirmed by the apex, the
Division.
guidelines provided by the division bench as affirmed by the Supreme Court goes into the question. The BDA cannot thereupon say that what is stated by that committee is not correct. The stand may not be correct anyway. That is
My lord,
to be
that won't-
decided in the.
My lord, contempt, my lord, what follows in the contempt, my lord, is only a mandamus I sought, my lord, because the recommendations will not be acted upon by the BDA. For 2 years, they did not acted upon. Hence, my lord, I came up before this on for mandamus. 3 months was given for them to consider.
All that may be correct, but to change or to tinker with a judgment which has gone up to the apex court and been affirmed and come back
But
may not be possible at this stage.
please, my lord, but in the honorable apex court as well as the honorable division bench, need not said, my lord, after the BDA has to take a call. It's for, as my lord rightly said, section 48(1), my lord, it's for the state to take.
If the BDA does take such a call, it is in those circumstances that you can raise these contentions.
Please,
Not
but-
here.
Please, my lord, but they won't.
Here in an appeal
Please, my lord, but
against a judgment which has already been affirmed.
please, my lord, but the portion which I read it, my lord, that was not in there in the earlier order of the honorable apex court division. If it's my lord's lordship has rightly understood, my lord, if the recommendation has to be final, the aggrieved person has to challenge the recommendation. My lord, the BDA cannot take a report. My lord, the report, my lord, whatever, they cannot be decided by the BDA. And my lord, moreover, BDA is a beneficiary, my lord. The beneficiary cannot, my lord, obviously, my lord, BDA was before the honorable committee opposing for a dropping of the land.
Happened in the contempt.
my lord, contempt is, my lord, only take a note of that proceedings and the complaint, the order of the learned single judge.
And this observation of the contempt court is that 48(1) has to be done by the state government and dropped it. Well, obviously, my lord, it is a 48(1) is to be done by the government.
Well,
not by
that
me.
will be on the basis of the BDS BDS endorsement, my lord. And my lord, that is why, my lord, I just want to stress on that, my lord, the portion, my lord, that whether based on the recommendation taken, they can take steps to further delete or include. No, they have to take only steps, my lord, they have to act upon the recommendation. If the BDA wants that, my lord, the recommendations are wrong.
Where is the judgment in the other set of appeals?
My lord, here.
That here is, my lord, I just.
Rather put-
Kamesh was saying.
There is one more and.
And my lord, the judgment which, my lord, the honorable, well, this point was not considered, my lord. That's what, my lord, I just want to make a difference. Because this is causing, my lord, landowners to again run behind the courts and the BDA. And my lord, the owner, my lord, was the order, my lord, recommendations. Again, my lord, there is no end for them to seeking deletion. Again, they have come up with the writ petition. And in the earlier occasion also, my lord, the same has been. My only request is, my lord, recommendation has to be final. That's all. Aggrieved person has to approach me. Only that clarification, my lord, I'm not at all arguing that, my lord, the order, entire order is to be wrong. I'm already before the committee, my lord, my representation is yet to be considered. They are going by village wise, my lord, my turn has not been come. With such clarification, my lord, this could be disposed, only a humble request. Only with such clarification, my lord, I have no objection. But as lords, you've seen the examples I produced. That will also be happen for all the persons, my lord, they again before the committee, my lord, again before this honorable court. So only the recommendation has to be final. That's the only request, my lord. Apart from that, I have no arguments and other validity of the acquisition, not even nothing. Only that portion, my lord, the bid has to straight away accept. If they agree, my lord, they have to come before, they have to challenge. Who are the agreed persons? That's only contention. I have no other arguments.
What do you say?
Lord, if your lordships were to take page 76, 746 of the learned single judge's order, my lord, since I have not been given a complete set of papers in the writ of appeal, may I request your lordships to kindly see 746 internal page of the learned single judge. Clause B, if the
In the page number 181, man.
Yes.
Lord, that B. The committee shall also consider, may I
Hmm.
consider the representation of the landowner submitted to the BDA, which shall be placed before the committee to ascertain as to whether the lands of the appellants are landlocked and or adjacent lands having been dropped from acquisition without dropping the lands of the applicants. The committee shall examine the claim on case-to-case basis and on being satisfied, either such claim being genuine or being contrary to a factual scenario, shall prepare a report village-wise and forward the same to the BDA to enable the said authority either to delete. Lordship, there are two directions which have been issued by the learned single judge to the committee. Committee will have to decide a case-to-case basis and a report will have to come a village-wise. But then to enable the said authority to either delete the lands from the acquisition or to conclude the acquisition. But here what has been referred to by my learned friend by producing these documents are in respect of a one particular portion of a property. I'm awaiting.
Has this exercise been completed by the committee? Have the matters been considered on case basis and
Case on case.
village-wise reports have been submitted?
Yes, my lord.
They have?
Insofar as the Kempapura village is concerned, which is most litigated portion of Arkavati layout, Kempapura village, but that has been now reserved by the honorable committee, and the committee has said that I will give you a village-wise report, so as to enable you to take it further. But that is what has yet been done.
So
But
once
what
a
happens
village-wise report is submitted,
Yes, ma'am.
then you agree that it has to go by that report.
But either I may have to agree, if I may not agree.
If
No,
you
it
do
is a
not agree-
recommendation.
If you do not agree, what do you do?
No, then if I do not agree, my lord, then I'll have to write it to the government and the BDA will have to take some decision in the matter. Because I'm not a person who has to delete it. Because it's only under 48(1), not the final notification under section 19 is also issued by the government. 17 preliminary notification is issued by the BDA. It's just a proposal of development. After that, then declaration of acquisition is done by the
But
state
you
government.
don't have a case that you have the right to reject the report of the committee.
Not then, not I cannot unilaterally reject it. I cannot unilaterally reject. Lord, this aspect, Lord, at the without the pleadings and Lord, what I looked into now is a particular portion of a property. Lord, if
Yes.
this is done, if an individual property is done, Lord, then again I'm back square one.
Yes.
9,494 acres, which was supposed to be acquired, acquisition was complete, out of which 945 acres of a land was deleted on a flimsy grounds that has been observed by the learned single. The entire order is not produced. The
Yes.
recommendation of the
That's
What was the
illegal.
ground on which you had actually
That's initially, my lord, I have
challenged it?
challenged for entire writ petition, my lord, entire order I was challenged. Later, my lord, I conceded, I will not go on because the other matters was dismissed. My lord, only, my lord, I also not argued on the entire proceedings. Only, my lord, as lordship has rightly said, my lord, only that portion. My ground, my lord, was entirely on the entire proceedings itself. Entire the order itself, I challenged, my lord, the grounds.
If that be so, then there has to be these contentions have to be placed on record so that they can.
Please, my lord, now also, my lord, they can just revert it back, my lord, on that places. No, let them
Let
want.
them get instructions in the matter then.
Yes,
Now it's
then-
being placed before them for the first time.
Please, my lord, they can have instruction on
Learned
that
friend should,
portion, my lord.
accept the fact that he'll not pursue his application before the committee because he's laying a challenge to the said order here.
My lord, so I-
What happens? He cannot take advantage of
He's
both
not
the orders.
laying a challenge. He says he's retracting all all the other challenge
then
except
he-
for this very.
Then he may have to move an application for clarification before the learned single judge.
Right.
There, everything, what happens is the entire facts of 4,000 acres and the decision of the decision taken by the BDA, state government, all the recommendations of the BDA to the state government, and by virtue of which they exercising a power were before the learned single judge. Matter was heard
All
for
that
3
is
years.
now, all that is now relegated to the committee to decide.
Yes.
These specific questions along with the guidelines in the earlier case are relegated to the committee to decide.
Yes.
If the intention of the learned single judge was that after which you have to take a call, then that would not be the, because ultimately now that a committee has been formed, the committee has to decide, and once the committee gives its report on a village by village basis or whatever, then it is for you to act on that report as far as you are concerned.
Yes.
You want instructions on that?
Then
Because
I'll have to take
it's
instruction.
only on that aspect that we are
State
proceeding.
will have to come, the state will have to say in it. State is the.
State is a party?
State is
a
also
party.
a
State
respond number
will
one.
have to say on it.
The learned government advocate as well as learned counsel appearing for the BDA to get instructions in the matter. The
Yes,
learned
ma'am.
counsel for the appellant submits that the appellant is not challenging the judgment of the learned single judge, which has attained finality, but is only seeking clarifications with regard to the action to be taken by the BDA and the state government on the reports submitted by the committee as directed by the learned single judge. List after 3 weeks.
3 weeks.
Yes, There's one more matter, my lord, it could be connected. 319 of 2022 writ appeal.
They're also this.
Same, my lord. Writ appeal, it could be connected.
It's a-
I know.
Yes.
14, Vishwajit Rai.
Respondent by.
The records are already received. Case was the Ultimately, the family, he could not be present, and had not got possession of the original records. The matter could be heard without the records, my lord.
The records may be required because I made it some notes on the base of the records,
We'll have it.
preferably after.
When do you want it? After a week?
28.
Yes.
Obliged.
At the request of the government advocate list on 28th.
15 urgent, 16. Renuka HR.
Waiting for respondent. Kindly place them. Hearing. Senior is held up in another court. 15.
There's an IA for stay, nobody appearing for the appellant.
TV.
Hmm.
17, MC Basuraj.
Termination of delay to 18 days, notice taken.
Yes. HR Renuka.
No, no. All the master meters, otherwise it won't happen. Only one is there. Hmm. Oh. Hmm.
Hearing on IS, number 80, Kartikeyan DS. The distance for non-prosecution.
9/1/23 for recalling the order in IA. Who appears?
Occupancy.
Is
Not
it-
complied.
Yes, week's time.
19, Hanmant Raju.
Filing delay. 721 days.
Absent. The council not filling them. Please give.
Hmm.
Yes.
That's right. Yes, list after a week.
20 disposed of, 21, Sanjay Kumar A.
Sorry, 95 days filing delay.
My lords?
95 days filing delay.
Yes, my lords.
Yep.
My lords, in this, my father had been expired in the month of December 2023. I could not able to file the suit on time, my lords.
Yes.
My-
notice.
My lords, one more submission. Defendant appellant number 2 in commercial OS number 87 of 2023 is defendant number 3. He is an employee in the company, my lords. Stay execution has been executed against the appellant number 2, my lords. He is the employee in the company, my lords. Hence, it is necessary for stay.
It's just been filed.
Yes, ma'am.
Please take out notice in the delay petition bill. List immediately after service is complete.
Warrant has been executed
As against whom?
against appellant number 2, my lords. 2 and 1, both of them, my lord. Business agreement have been signed by the company, my lords. Nowhere appellant number 2 is been signed, my lords. My humble request for the honorable court is that to grant the stay order.
3,68,785.
Yes, my lords.
Interest at 18%.
Yes, my lords. In commercial execution 479 of 2024, they have issued a warrant, my lords, against us.
Delay.
Second, the delay. What is the delay? How many days delay?
95 days, my lords. Due to my father had been expired in the month of December 2023. Like 2 months, I could not able to come for. I have filed application for stay also.
Yes, application for stay can be considered on payment of some amount,
Uh,
50%.
my lords, at least notice might be served.
Yes. Notice in the IA also.
Yes. 22 urgent, 23 Amityam Hegde.
So the applicant,
23, 24, 25, 26.
all are
Notice.
connected.
Notice.
Notice, my lord, kindly maybe order to serve it on a council appearing for the
Yes.
the
in
National
addition.
Highway Authority.
In addition,
Please,
by serving on the council appearing in the,
any council,
To pay the process also.
in addition.
in addition.
Yes.
My lord, kindly, respondent number 3 is the arbitrator, my lord. It may be dispensed,
Yes. Notice to the third respondent is dispensed.
may all be connected. Thank you. Much obliged.
27 Prithvi Shamke.
That's 27, I appear for the petitioner minutes. Requesting for a short accommodation in this matter, my lords. Any
For
date
the
next
last
week.
date also, my lords, they've taken an adjournment. My lords, this is a matter where there's already a status quo, my lords, in their favor, the service matter, my lords. It was adjourned on an understanding that, my lords, the arguments will go ahead. Yes, my lords, granting
you-
an adjournment also, a short date may be granted.
Yes. Short date, give a short date.
23rd. 23rd.
I'm grateful. Lords. Till then, interim order may be extended.
Yes, till then.
I'm grateful.
Great.
Number 28, further arguments, Sunil PP.
Respondent. The section 8, my lords, application came to be rejected. Lords, the impugned order, my lords, is at annexure A, page 20. Lords, three aspects, my lords, which requires consideration by this honorable court. Whether, my lords, the arbitration.
Just a moment, please.
Yes, please.
Just a minute. Yes.
Lords, the section 8, my lords, application came to be filed in pursuance of the, my lords, offer which has been given, lords, which has been given to the respondent herein. Before execution of the contract, my lords, what the trial court refers in document number 1. What they have filed is, my lords, document number 1, which is the contract what they are referring to. Document number 8, my lords, filed along with the plaintiff, my lords, is the offer which I am referring to. I have filed this application before the Honorable Trial Court to send the matter to arbitration under section 8 because, my lords, the offer contains an arbitration clause. If my lords could see the document, my lords, I have filed my paper book. Instead of that, my lords, along with the statement of objections, they have filed, my lords, these two documents. Therefore, I would request, my lords, to kindly peruse the offer, my lords, based on which this application came to be filed.
Yes.
Page number 59, your lords. 60, my lords, 61. Clause number 20, my lords. Contains, my lords, arbitration clause. Page 61. Ink page, my lords. Ink page 61.
Yes.
Filed along with the statement of objections. My lords, clause number 20. Contains, my lords, arbitration clause. May I read, my lords? If any dispute, controversy, or claim between the parties arises out of or in connection with this contract, including its existence, breach, termination, or validation thereof, the parties shall use all reasonable endeavors to negotiate with view to resolve the dispute amicably. In case of dispute or claim, both the parties will make all efforts to try and resolve through mediation with the help of the mediation center based in the customer place of jurisdiction. Suit if still if the dispute claim is not settled within 30 days of such reference, then the parties are agreed that the dispute shall be finally resolved by arbitration as per the provisions of Arbitration and Conciliation Act 1996 and amendment thereto by a sole arbitrator to be appointed as per the applicable legal process. Lords, this is the basis, my lords, on which the application came to be filed. My lords, that apart, there is a separate, my lords, arbitration agreement which my lords finds at page 63. There is a separate arbitration agreement. That also, my lords, is the clause number 20 is replicated, my lords, in clause in page 63. That is a separate arbitration agreement. Same thing, my lords, at unnumbered last paragraph, my lords, before the witness column.
Valid contract number, so and so that number,
Yes.
that refers to a.
Refers to, my lords, document number 1. Offer also. Valid contract, my lords, the reference of offer has been quoted there. My lords, this is the, my lords, agreement. This, my lords, agreement has been communicated to the respondent. Pursuant to this offer, a contract came to be executed. And there is a reference of this offer also in the contract notes. Kindly see, my lords, contract at page number 7.
Yes.
Lords, at reference, if your honor, if my lords, the reference column, my lords, which refers to the offer, which has an arbitration clause. The offer, my lords, referred to is the document number 8, produced along with the plaintiff. Lords, the core contention raised by the defendant, rather respondent herein, that two contentions were raised, my lords. One is that the offer has not been signed by the parties. Therefore, my lords, the parties are not conducive, my lords, it is not a valid arbitration agreement to refer the matter to arbitration. That is the
Then whether this would be whether you had decided among yourself to actually have an arbitration, I mean, to refer any disputes to arbitration or not.
yes, please, my lords.
What
There
does
is
the commercial code say?
commercial court's view, my lords, insofar as in these two objections are concerned, one, my lords, holds in my favor. Another, my lords, the trial court proceeded.
Does not have to be in writing and it does
Yes,
not have
please.
to
It need not be signed, my lords.
be signed.
Need not be signed, my lords, is
Accept.
that has been accepted. Lords, the trial court further goes to find out whether there is a valid arbitration agreement or not. Lords, in the further findings. That is the reason, my lords, why I am before this court. Lords, whether, my lords, this comes under the jurisdiction of honorable trial court or whether this question, my lords, has to be decided by the arbitrator. They have all the contentions, all the rights to raise these points before the arbitrator also. My respectful submission is the trial court, my lords, has no jurisdiction to find out, my lords, whether there is an arbitration agreement or not. When, my lords, it is an arbitrable dispute. My lords, if it is a non-arbitrable dispute, my lords, the trial court has to find out whether it is an arbitrable dispute or non-arbitrable dispute. This is a clear case, my lords, for recovery of money. According to me, my lords, this is an arbitrable dispute. The Honorable Supreme Court also says, my lords, when it is an arbitrable dispute, the matter has to be referred to arbitration, not to be, my lords, decide whether, my lords, mini trial cannot, in this question, mini trial cannot be conducted, my lords, is the Honorable Supreme Court's findings. Therefore, my lords, I am before a lordships on this particular issue. Well, holding, my lords, one point in my favor, and, my lords, proceeding further to find out whether there is an arbitration clause or not. Lords, is not within the scope of the Honorable Trial Court's view, purview, my lords. This is my respectful submission. I am, my lords, placing, my lords, few judgments in that regard. When, my lords, the arbitration tribunal itself has the jurisdiction to find out whether there is an arbitration clause or not. Lords, whatever trial court has done, lords, is out of the jurisdiction, my lords, is the Honorable Supreme Court says. Irupodi.
You are the defendant in this.
I am the defendant in this. May I point out, notes before I read the judgment, notes, may I point out few of the observations in the impugned order? Paragraph number 12 of the impugned order, notes.
Yes,
The Honorable Trial Court, notes, considers, notes, the two objections raised by the
yes,
respondent. Lords, the question, Lords, at paragraph number 16, may I read, Lords, paragraph number 12 for a while. It is to be noted that the offer issued by the defendant to the plaintiff dated 23/11/2021 is produced as document number 8 along with the plaintiff. The contract agreement between the parties dated 24/11/2021 is produced as document number 1 along with the plaintiff. Whereas the offer letter discloses that admittedly contains arbitration clause. Here, Lords, the trial court says the contract offer contains arbitration clause. On the other hand, the contract agreement does not contain an arbitration clause. Admittedly, offer letter is signed only by the defendant and not signed by the plaintiff. It is the contract agreement which is signed by both the parties. In this background, the question that arises for consideration is whether arbitration clause contains in offer letter forms part of the agreement between the parties, and hence there is a valid arbitration agreement between the parties. Lords, this is, Lords, the question which came up for consideration. Kindly see, Lords, paragraph number 18. At page 13 of the impugned order, my Lords, ink page 32.
yes,
No doubt, as laid down in the rulings relied on by the learned counsel for the defendant, that is the appellant herein, it is not necessary that the arbitration agreement should be signed, and it is sufficient if it is writing. Lords, that contention, Lords, has been accepted. Now, Lords, this reading goes, Lords, to say that there is an arbitration agreement, Lords, which need not be signed by both the parties. This has not been challenged by the other side. This observation has not been challenged. The further, my Lords, the Honorable Trial Court proceeds to find out whether the matter is arbitrable or not, and under which agreement.
court says in all cases it need not be signed.
Yes, please.
This is all it says. Then further on.
Further, my
the
Lords,
rest of your case, what does
but
it say?
in the
What
case on
case?
hand, there is
no-
nothing to indicate that the parties were not at the consensus addendum that the terms of the offer letter is binding on the parties, or that the offer letter is incorporated by reference into the concluded contract. In the plaintiff is not relying upon the offer letter for the relief claimed, but is relying only upon the concluded contract. And Lords goes on, Lords, with to find out, Lords, whether this is applicable or the contract is applicable to refer the matters for arbitration. Lords, what my respectful submission is, Lords, if the Honorable Trial Court only sees that this dispute is arbitrable and decided by the arbitrator, all these, my Lords, they need not be looked into, is, my Lords, my respectful submission, whether there is a valid contract or not. When, my Lords, section 16, the arbitrator, my Lords, is empowered to decide on all these aspects, whether there is a valid agreement or not. All this, my Lords, comes within the purview of the arbitrator, is my respectful submission. Kindly see, my Lords, section 16 of the Arbitration Act.
Let's go to section 8 first.
Section 8 is, please. Lords. Power to refer parties to arbitration where there is an arbitration agreement.
Where there is an arbitration.
Yes, that's all, my Lords, is my
Yes.
contention.
Hmm.
Because there is an arbitration agreement.
Yes,
my Lords?
please.
Yes, please. A judicial authority before which an action is brought in a matter in which the subject matter of arbitration agreement shall, if the party to the arbitration agreement or any person claiming through or under him, so applies not later than the date of submitting his first statement on the substance of the dispute then notwithstanding any judgment, decree or the order of the Honorable Supreme Court or any other court, refer the parties to arbitration unless it finds prima facie that no valid arbitration agreement exists.
Yes.
An application referred, Lords, this has been clarified, Lords, is my respectful submission in the judgment of the Honorable Supreme Court. The application referred in subsection 1 shall not be entertained unless, Lords, unless it is accompanied by an original arbitration agreement or a duly certified copy thereof. Provided that where the original arbitration agreement, Lords, this is all not relevant, Lords, because that is not the question which has been urged. Now, Lords, kindly see, Lords, the judgment what I have to answer this point, Lords, what is there in section 8(1) of the Arbitration and Conciliation Act. Before that, Lords, may I read section 16 also?
Please.
Competence of the arbitral tribunal to rule on its jurisdiction. Lords, the arbitral tribunal may rule on its jurisdiction, including ruling on any objections with regard to the existence or validity of the arbitration agreement. And for that purpose, an arbitration clause which forms part of the contract shall be treated as an agreement independent of other terms of the contract.
Yes.
Lords, this is, Lords, which comes, Lords, within the purview of the arbitral tribunal to decide whether this forms a valid contract or not.
Yes.
Because, Lords, now offer has been referred in their contract and parties have subjected themselves to terms and conditions of the contract as well as the offer. All these, Lords, contentions are left open to me to urge before the arbitrator. Prima facie, Lords, trial court finds that there is an arbitration agreement. Now, Lords, kindly see the case, Lords, reported in 2011 5 SEC 532. Bozala and also Hamilton INC. May I directly take to paragraph number 33. Page number actually. Page number. Lords, this deals, Lords, with the dispute which is arbitrable and, Lords, non-arbitrable. When, Lords, the dispute has to be referred to arbitration, and, Lords, when, Lords, it has to be tried by public fora like, Lords, civil court. When it is right to personam, Lords, the Honorable Supreme Court says it is an arbitrable dispute which has, if there is an arbitration, an agreement, this has to be referred to arbitration and decided by the arbitral tribunal itself. If it is a,
Relying on paragraph 33?
please, Lords, yes. Please.
You're relying on paragraph 33?
Yes, yes. But where the issue of arbitrability arises in the context of an application under section 8, it is in a pending suit, all aspects of arbitrability will have to be decided by the court seized of the suit and cannot be left to the decision of the arbitrator. Lords, further, Lords, even if there is an arbitration agreement between the parties, even if the dispute is covered by an arbitration agreement, the court where the civil suit is pending will refuse an application under section 8 of the Arbitration Act to refer the parties to arbitration. If the subject matter of the suit is capable of adjudication by a public forum, or the relief claim can only be granted by a special court or the tribunal.
Not the case here.
No, that is the case. This is a dispute, my lords, for recovery of money which is arbitrable. Recovery of money, my lords, is arbitrable. If it is not, my lords, cannot be decided by the arbitrator because parties are ceased to be under any other restrictions. Only then, my lords, it can be tried by the court. Kindly see, my lords, paragraph number 34 also. The term arbitrability has a different meaning in different contexts. The three facts of arbitrability relates to jurisdiction of the tribunal are as under whether the dispute are capable of adjudication and settlement by arbitration. If a suit, my lords, can be adjudicated by the arbitrator, then, my lords, it has to be referred to arbitration. That is, whether the dispute having regard to the
There
nature.
is an arbitration clause.
Lords?
Provided there is an arbitration clause.
There is an arbitration clause and my lords, if the matter is arbitrable in nature.
Provided there is an arbitration clause.
Lords, that question, lords, has to be decided by the arbitrator itself is what, my lords, the judgment says. Kindly see, my lords,
Not
further, I may
not
be,
in section 8.
my lords,
Not in section 8.
my lords, I will further take your lordships to that particular point. Whether the dispute is capable of adjudication and settlement by arbitration. That is, whether the dispute having regard to their nature could be resolved by a private forum chosen by the parties, that is the arbitral tribunal, or whether they could exclusively fall within the domain of public courts. Whether the disputes are covered by arbitration agreement, that is, whether the disputes are enumerated or described in the arbitration agreement as a matters to be decided by the arbitrator. Lords, here, lords, I will take a pause, lords. Whether the disputes are covered by the arbitration agreement, that is why the disputes are enumerated or described in the arbitration agreement as the matter to be decided by the arbitration, or whether the dispute fall under the accepted matters decided by the arbitration, or whether the dispute fall under the accepted matters excluded from the purview of arbitration agreement.
Yes.
Whether the parties have referred the dispute to arbitration, that is whether the dispute fall under the scope of submission of tribunal, or whether they do not arise out of the statement of claim and the counterclaim filed by the arbitral tribunal. A dispute, even if it is capable of being decided by the arbitration and falling within the scope of arbitration agreement, which not be arbitrable, if it is not enumerated, is the joint list of dispute referred to arbitration, or in the absence of such joint list of dispute, does not form part of the dispute raised in the pleadings before the arbitral tribunal. The arbitral tribunal are the private fora chosen voluntarily by the parties to the dispute to adjudicate their dispute in the place of the court. The tribunals, which are the public fora constituted under the law of the country, every civil or commercial dispute, either contractual or non-contractual, which can be decided by the court, is the principle of capable of being adjudicated or resolved by the arbitration, unless the jurisdiction of the arbitral tribunal is excluded expressly
Yes.
or by necessary implication. Adjudication of certain category of proceedings are reserved by the legislature exclusively for public fora as a matter of public policy. Certain other categories of cases, though not expressly reserved for adjudication of public fora, courts or tribunals, may be necessary implication stands excluded from the purview of private fora. My lords, this is a suit for my lords recovery, which is, my lords, can be adjudicated only by the, can be adjudicated by the arbitration tribunal is my respectful submission.
Yes.
36, my lords. Paragraph number 36.
The very same judgment.
Same judgment.
Yes.
Which deals with, my lords, non-arbitrable matters, which cannot be, where the parties cannot subject themselves to arbitration, or the dispute cannot be decided by the arbitral tribunal.
You understand. What is the next judgment?
This is, my lords, therefore, my lords, the trial court getting into the aspect, my lords, to find out whether there is an arbitration agreement or not, which can be decided, and also, my lords, the dispute being an arbitrable dispute which can be resolved by the arbitrator, ought not to have, my lords, proceeded further. Instead, my lords, the matter ought to have been referred to arbitration.
Is it your contention that only because you say that it is an arbitrable dispute, it has to be referred to arbitration?
That is, my lords,
What is the purpose of section 8?
lords, section 8, lords,
The court has to consider whether there is an arbitration agreement that is the limited scope of the power of the court. The court has to see whether there is an arbitration agreement and whether the dispute is arbitrable. These two are the only matters that the court needs see.
yes, please.
That cannot be taken away from the court.
Lords,
That basically is a question the court has to decide in section 8.
lords, under section 16, all those contentions are, my lords, left open.
if, as a
If, my
matter of
lords,
fact,
prima
it is-
facie-
there is an arbitration
Yes, my lord.
clause.
Here, saying that, my lords, there is an arbitration agreement in the findings. Saying that there is an arbitration which need not be signed by the parties.
That is not
Valid,
said.
valid.
That according
Yes,
to
my
them is
lords,
not said.
I got my lord's point.
It
whether-
only says that in all cases, the arbitration, if it is in an offer letter, it does not have to be signed by both parties. That is all it says.
Yes, please.
But in your case, considering your case specifically, the court comes to the conclusion that there is no arbitration clause as such in the agreement.
I will also, my lords, I will also point out, my lords, even those the references
Ah.
are also, my lords, is not correct. In the given facts and circumstances of the case. Let me just hear what has happened.
Here to this contract, they have prepared this. Okay. Yes, please. We will take a deep 24 minutes. Before going into agreement, it defined as prepared this offer letter. There was no contract between that day, the 23 letter. There was no contract between the parties. Only as prepared this. That. The agreement date is 20.
Today, it's only 26. I think we'll have to hear.
Yes, please.
We'll-
Any date may be fixed.
Reserve.
The whole
Go ahead.
difficulty, my lords, last to precipitate. The matter is coming up tomorrow.
Will not be precipitated.
Otherwise, my lords, if the proceedings, my lords, why? Because it so happens, my lords, the trial court insists me to file the admission and denial
The
statement.
only question we now have to decide
Yes,
is
please.
whether
That is the reason.
that offer letter had been accepted in the contract.
Yes, please.
If it is not, that is the end of the matter.
That is all.
Because just saying that the court cannot decide on the question, court, that is what the. court
Lords,
has
that
got-
also, my lords, that also, my lords.
The only thing the court has to see
No.
is whether there is an arbitration.
That
clause
also, my
between the
lords, I will address, my lords, that also trial court cannot get into all those aspects.
Yes. Then what can the trial court go into in section 8? If you're saying that, then the answer would be in every case where the defendant says it is arbitrable, it has to go for arbitration.
Not like
It is
that.
not so.
No, depending on the facts and circumstances. That
Exactly.
also, my lords. I
Facts
will-
have to be looked
Yes,
into. and
please.
The court has to
Yes, yes, yes.
decide whether there's an arbitration clause entered into between the parties. It need not be signed.
Signed
but it
or,
has
my
to-
lords.
There has to be a meeting of minds between the
Yes, please.
parties as to
Yes,
whether the
please.
matter is to be referred
Please,
to arbitration.
please,
That is the issue which has to be considered.
oblige.
Yes. When do you want it?
Any date, next week or convenient to the court, my lords.
Yeah.
Till then, my lords, let the trial court.
Yes, list on 30th.
I had some difficulty.
Yes.
Sometime earlier members.
Well, 20. 28th. What about 28th? 28 can be?
28 years.
List on 20th, the trial court shall not proceed with the trial of the suit till the next date of hearing.
Oblige.
Maybe we posted for at 2:30 minutes, Mr. Lodge.
2:30.
Great.
Great.
Then make it 27th and can it be 27th, council? Just a moment. 27th. 27th, there is a 2:30 matter. 28th, there's a 2:30 matter. We'll have to, 29th. Is that all
29th.
right?
Very well, minutes. Grateful minutes.
2:30.
Passed on matter. Till number 6, Ravindra Gajana.
Please, my lords. Being agreed by the award passed by the Honorable sole arbitrator upon issue of notice for the second time, my lords. The first time a notice was issued way back in the year 2016. Thereafter, a CMP was filed, which came to be withdrawn in the year 2019. Again, in the year 2020, a fresh notice was issued and sole arbitrator was appointed without obtaining consent from the respective parties. There itself, this entire award passed is ab initio void. So even in the first notice itself, it has been categorically mentioned that at page number 92 in the last paragraph, I may kindly be permitted to read, my lords. Page 92.
Yes.
Hence, I hereby call upon you to settle remuneration, profits, statement of accounts, and bank details, etc., as per clause number 7 and 9 of the partnership deed dated 1/4/1992, from 2004 to till date, because it is a deadwood. It is totally barred. The claim is barred by limitation. And same is reiterated in the arbitrator or sole arbitrator's award, which is produced at Annexure B at page number 57, my lords. Page number 57 at paragraph number 13, issue number 4, my lords. In the middle portion, if I may be permitted to read, my lords. His affidavit, the claimant stated that rupees 25 lakhs from the date of claim petition, which he is entitled to as per the business carried out by the respondents in the name the firm, and it is further stated that when the ejectment suit in OS number 1192 of 2004 was filed, from 2004 to till the date, the respondent had not paid the remuneration, profit, etc., etc. So it is also reiterated in the second set of arbitration proceedings, and the award also is passed on that basis, my lords. It is basically an ex parte order, wherein consent of the parties was not obtained. And my lords very well know the latest decision delivered by Honorable Apex Court reported in that is Parkins Eastman Architects versus HSCC, reported in citation. I understand it is not reported, but anyway, I will produce this, my lords. At paragraph number 16, my lords, I may kindly be permitted to copy for the reference. At page number 23 of the decision, my lords, at paragraph number 16, at relevant page at 24, the opening sentence, page number 24. Naturally, the person who has an interest in the outcome or decision of the dispute must not have the power to appoint a sole arbitrator. That has to be taken as the essence of the amendment brought in by Arbitration and Conciliation Amendment Act 2015 and recognized by the decision of this court in TRF limited case.
So the position of law has taken a paradigm shift, my lords. So herein, previously, when first notice was issued in the year 2016, a CMP was filed. And that said CMP came to be withdrawn. The certified, copy of the CMP I have produced, my lords. Annexure H at page number 98 of my appeal memo. Page number 98.
Yes.
Annexure H, the last order portion at 99 in the bottom portion, my lords. After arguing the matter for some time, Shri so-and-so, learned counsel for the petitioner, has filed a memo to withdraw this CMP with liberty to the petitioner to avail the alternative remedy in accordance with law. Next, memo is placed on record. CMP is dismissed as withdrawn with liberty as prayed for. But here, no doubt, my lords, I think the lords therein have granted the liberty, but I don't think that there is any other alternative remedy. It is only end of the case. Having once taken up recourse under section 11(6), my lords, it is impermissible to initiate second round of litigation of appointing arbitrator privately, appointing one advocate as the sole arbitrator. When the dispute subsists, naturally they should have, in the second instance, also ought to have recourse to CMP only. They ought to have availed the opportunity provided under Arbitration Act 11(5) and 6, and then got the arbitrator appointed at the intervention of my lords or respective courts, as the case may be. So it cuts at the root of the case. The entire arbitration proceedings which has taken, or eventually it came to be culminated at Annexure B at page number 51, my lords. Relevant portion.
Yes.
Therein, this award has been passed. That has been now impugned herein, my lords. So herein, the learned arbitrator, sole arbitrator, without giving any reasons, no reasons have been assigned, simply awards a sum of rupees 25 lakhs. And it's basically a matter pertaining to accounts. The statement of accounts, books of accounts, bank statements, and so many other documentary evidences which are normally available in a business transaction should have been produced and marked as exhibits. Nothing is found there. At page number 58 also, the list of annexures is also produced. Therein, no such things are forthcoming. So I don't know under which basis the learned arbitrator came to the conclusion that the parties are liable to pay 25 lakhs rupees. It is without any account. So when it is absolutely dead issue, so it's a wasteful exercise. So based on such an award, I think the appellants moved the jurisdictional court Annexure A at page number 33, my lords. It is the award that has been passed totally on erroneous grounds. And even to this day, I am not delivered with a signed copy of the award.
Yes.
Even without delivering me, despite my making a documentary request, it is not supplied to me. But whereas he proceeded to initiate execution proceedings. And in that, my lords, the proceedings are so that they will anytime knock the doors of appellants for attachment of the movables and whatever is that available. Per se, it is a bad, that's why I am requesting for grant of stay on the proceedings as well also on the execution petition, my lords.
Yes.
Lord. Pensions rise, my lord. Partnership is this partnership business belongs to the family members, mother and 3 sons. Initially, page 65, next shall see of the petition. Take my lordship. Page 65. Is a family partnership, mother and 3 sons. Page 65 is the partnership, deed of partnership marked at annexure seal. Take to the last para of the same page. Whereas first party carrying on business in liquors under the name and style of Messrs. Variety Wine Shop in premises at number 16H Road, Bangalore 27. Oh, my lord, initially the liquor license was registered in the name of the petitioner, late K.V. Tulsi Rao. That has been infused to the partnership business, my lord, where their investments were to be shown at page number 67, clause 7. On the first rupees 75,000 of the book profit, or in case of loss, there shall be a ratio of percentage wise profits or loss to be equally divided between the partners. If I take my lords to the clause 13 at page 69. Here it stands, death, retirement and insolvency or insolvency. If the firm shall not be dissolved by reasons of death, retirement or insolvency of any of the partners, the business or partnership shall be continued by the remaining or the surviving partners. One aspect now where one of the partners being the mother demises, the remaining partners continue. Clause itself says no legal risk. The remaining partners continue. So the remaining partners are the 3 sons who continued the business. See, initially the first partner Tulsi Ram was the person handling all the liquor license, the books of accounts and everything, and used to share the profits out of it. Now at clause 14 is the arbitration clause. If any disputes or disagreement arises in the respect of this partnership or any matter arising therefrom or connected therewith, the same shall be settled by arbitration according to the arbitration. Having basis of this, there was a dispute of the liquor license shop which was rented. The landlord had filed a ejectment suit. That being the time, my lord, we had closed the shop for some period of time where there was no remuneration or any profits arised out of it, that it was not shared with the partner. That being put, my lord, he shifted the premises after the ejectment suit was decreed in favor of the landlord. That was not brought to the knowledge of the other parties. He continued in the business in his individual name and not even informed the partners about the dissolve or the settling of the accounts. Then one of the partners, being this respondent, had issued a notice 2016. That my lords find it at page 90, annexure E. First notice issued. The first partner always had the petitioner late K.V. Tulsi Rao had a reasons always that there was no business continued due to the ejectment. The business is not continued. We have to find a place for it. The notice was issued stating that my lord at page number 92, calling him on to settle the remuneration, profit settlements of accounts and bank details, etc. as per clause 7 and 9 of the partnership deed dated 1/4/92 from 2014 data. That is to 2016. Then, when he was continuously followed, that was acknowledged and replied, my lord, on next page number 93. He replies through his counsel. On 10/8/2016, he replies to the notice at page number 94, para number 4. My client instructs me that due to the loss in the business and evicted by the from the shop,
The aforesaid partnership business was also closed and settled account to you, client, as well as other partners of the business long back, knowing fully well your client is habit of making false claims and filling false. This was the reason he has given my lord without any documentary evidence to show that there was any dissolve of the partnership or any loan accounts were settled. Any remuneration or profits were shared to them. No accounts details have been furnished along with the notice. Bluntly stated in the paragraph. In continuation of that, my lord, at page number 95, next G 28/10/2016 is a notice which is issued for appointment of arbitrator since there was dispute between the parties. Page number 95, 97.
Yes.
There was one Mrs. Radha, retired district and session judge, who was nominated for the appointment as an arbitrator. Thereafter, my lord, there was no concurrence from the petitioner sides. CIP filed this for appointment. Arguing after some time, I was the one who was arguing the same. Lordship had then instructed to take another notice and take concurrence from them and then initiate. That was the instruction, my lord, already done. So that is why there was a.
Was concurrence taken in the,
No. There.
thereafter was concurrence taken?
No. I'll continue. I'll continue.
You're at 4:45 comes. What is the urgency in the matter? We can.
So only execution may kindly be stayed. That's what's the only request, my lord. No, when they.
Give it to the court.
Yes.
Serious matter also considered. in detail.
Yes.
Only one point I made that because the capital of the firm has been repaid, it is reflecting at page number 116, my lord. It's an order passed by the learned sessions judge, my lords. So partnership came to an end. There is no point in going back to 2004, 2006, and it is, no, that you are not.
We are of the opinion that the issue requires a deeper consideration. List after 2 weeks. In the meanwhile, proceedings in execution shall not be precipitated till the next date of hearing.
517.
2
Please.
weeks. We'll give a date for that lady. Tomorrow day after, please, please.
That can be had next week, my lords.
ಇಷ್ಟು ದಿವಸ ಮಾಡ್ದಾನೆ ಇರೋದು ಇವತ್ತೇನು